Any mention?
May I please, Your Lordship?
Yes.
My Lord, item number 31 and 38, my Lord. I have some personal difficulty today, my Lord. So, can this matter be adjourned for a week only?
31 and?
38, my Lord.
Other side?
I have informed Mr. Sangma and I have
He
informed
always objects.
No, I have informed him.
You are willing to give adjournment? No objection? No objection. Very good. Okay, 2 weeks. Yes.
Hello.
Your Lordship, beg to mention item number 33 and 41, Your Lordship.
May I please, Your Lordship?
1 second, 1 second.
You mentioned
Lordship,
33
I
and?
like to mention
41.
item number 29 of today's
1
list.
second, 1 second. The other mentions gone. Please wait.
Lordship, conducting counsel PG Borthapur's murder is in ice.
MS Hussain, please wait. The other lawyer is mentioning right now.
Lordship, we need
Who's
4 weeks
handling
time
video?
with the consent of the other side, Lordship.
Tell to wait. No courtesy. Yes.
Item 33, Your Lordship.
No problem.
What the reason? 1 week, 19 matter.
Also, item 41, Your Lordship.
Item?
41, Your Lordship.
Why you adjourning the matters?
Mr. Nongri couldn't come today, Your Lordship.
2 weeks, yes.
Highly obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 43 of the main list.
40?
3.
Yes.
That the conducting counsel is out of station, so I said the letter.
Who's the conducting counsel?
BDF.
3 weeks, yes.
My Lord, item number 32. My Lord, can please this matter after 2 weeks, my Lord. 32, my Lord.
No objection.
2 weeks. Yes, 32.
May I please, Your Lordship, I would like to mention item number 21 to 26. My senior is on sanction leave, so this matter can be...
Who's on sanction leave?
Sakurishi.
Where's Mr. Manta?
We have already informed.
No question. We already are very well aware that this matter is fixed. Show that matter is to be disposed of in the next 2 days. Correct.
But my senior is on sanction leave, so...
I wish I was lucky as your senior just put sanction leave and when is the last order? See, you prayed only the listed today, 19.4. Right, in spite of the petition counsel for the appellant seeking a general matter to today for hearing, yet another request made for adjournment on account of being sanctioned leave. So, in the interest of justice, this matter after 1 week.
2 weeks, Your Lordship. 2 weeks.
Why?
Sir is having some personal difficulties.
Okay, 2 weeks. Or you take the file and argue it. Okay. How many juniors does Mr. Kuriji have?
2.
You and?
One boy is there.
Senior to you?
Yes.
Okay.
Obliged.
Yes.
Lordship, I beg to mention item number 30.
13?
30. 30.
30.
Let it come after 2 weeks, Lordship.
30. You have 2 weeks. Yes, worth mentioning item 29, MS Hussain. Yes.
May I please, Your Lordship?
Yes.
Conducting counsel Mr. PT about suppose matter is in ICU. So we need 4 weeks time, Lordship. With the consent of the other side, we have taken the consent, Lordship.
After the statement, they inform you. Lordship.
4 weeks. Yes.
4 weeks, Lordship.
Obliged.
Yes.
Obliged, Lordship.
Supplementary list, item number 1.
I'm praying if this matter can be taken at the bottom of the board. Mr. Paul is appearing this matter.
On what ground are you challenging the election?
Lordship, on there is subsisting contract, Lordship, in respect of
Subsisting contract,
Lordship
which is being undertaken by the
by this
return candidate.
return candidate.
After some time.
Lordship, item number 2 as well.
2,
2 as well, Lordship.
3,
May I please, 1 second. Yes.
My Lord. My Lord, I am challenging this election on the grounds of substantial concealment of the information by the returning candidate. Lord.
That means on affidavit only.
Yes, Your Lordship. On the
Yes.
affidavit part.
Yes.
Yeah.
Continue.
May I lead my Lordship to para number 20, Lordship.
20.
Yep. May I, Lordship?
Yes.
Yeah. That the affidavit under Form 26 prescribed under Rule 4A of the Conduct of the Election Rule 1961 filed by the respondent number 1 suffers from the following defects of substantial character. In the beginning of the affidavit, respondent number 1 solemnly assured that the social media accounts he operates on different application platforms. However, the information provided by respondent number 1 is inadequate. That is to nature to conceal the true and correct information, my lords.
What is information which is not called suppress? That is mobile number.
Yes, Your Lordship. There are so many mobile numbers they are using to operate the WhatsApp accounts, Your Lordship. But he has just given only one telephone number. But there are other WhatsApp numbers also. And besides this, my lords, if I may directly go to on page number 22.
Yes.
Para 4, my lords. The details of the PAN card number and the status of filing of income tax return also, Lordship. In this regards, Lordship, my humble submission is that as far as the serial number 1 of where the respondent number 1 has stated that affidavit.
Where is that affidavit?
My lords. My lord, it is on page number 53, my lords. The annexure 3, my lord. Page number 53. 3, lordship.
Now we know that part regarding PAN card.
Yes, your lordship. It's 53 and then 54, and on 55, lordship. The first para, first column, self Rupa and Marat, no PAN allotted, your lordship. Page number 55, lordship. This annexure starts from page number 53.
Right. Yes, I've seen that. Self, no PAN allotted.
No PAN allotted, my lords. Whereas, as per the rule, my lords, if my lords may allow me to go into the details, he has stated that no PAN allotted under the heading PAN and filing of ITR is not applicable. My submission is limited to 2-3 aspects of lordship. That the point number 1 is that the detail of sources of income respondent number 1 disclosed in his sources of income under the self-employed category, lordship. In the 9B, there is another column in the affidavit, lordship, where he need to disclose his source of income. And whereas he has disclosed that his source of income is self-employment, my lords. Now, earning business income without a PAN number, your lordship.
Yes.
That's my lords violate the.
Okay. Next point.
The next point, lordship, within this also, that on page number 23, lordship, 5th line, it is not out of context to mention that the saving account of respondent number 1 in SBI Radangiri branch had more than INR 1 lakh rupees. Therefore, it does not fall in the category of BSBDA, that is the basic saving bank deposit account, lordship. So it operates only up to the limit of 50,000, your lordship. So this is one part, my lords. I have given the order circular also, your lordship, whereas it is essential to. Now, if I may come to the 21 page para number on 24 page number, your lordship. That in para number 5 of form 26 affidavit, every candidate is bound to disclose the true and correct information about the pending criminal cases against him. It is respectfully submitted that respondent number 1 misleadingly declared that there is no pending criminal case against him. Whereas, lordship, there is a FIR filed by Srimati Sultana Bibi, widow of late Mukibul Islam, and lordship, this is as a supplementary FIR, it is pending against him. If I may lead my lordship to para number 22, my lords.
Yes.
This is related to the movable assets, your lordship. Yes. Para A, your lordship. 7A, serial number 1 to the respondent number 1 under self column, disclose the amount to the tune of rupees 61,000 as cash in hand. However, there is ambiguity, your lordship. We are not clear, your lordship, it is as far as the last assessment year is concerned or at the time of filing of the as per the rule, your lordship, you need to file as per the last assessment year, lordship. Now, if I go to the next para, lordship, this is the same thing. There is a replication as far as the spouse column is concerned. Again, he has given the amount but not disclosed the date, lordship. And para number C, lordship, this is also very significant as far as the election is concerned, your lordship. Yes. That the respondent number 1 failed to disclose the election expenditure account specifically. There is no information at all that from which account he is actually managing his election expenditure. The same thing is again he concealed deliberately, my lords. Now, as far as D is concerned, this is something very, very glaring example in what manner he tried to conceal the information. In para number 7A, S1 serial number 3 of the respondent number 1, he disclosed only one account of his spouse, Srimati Deepti Marak. My humble submission is that, your lordship, that Mrs. Deepti Marak, the wife of the respondent number 1, the returning candidate, he is having 2 more accounts, your lordship. That is on page number 27, account number 1 and 2, your lordship.
Okay. Next point.
Next point, my lords. Yes, your lordship. In the same, the next paragraph of 27, rather third paragraph, it is further submitted that as per the salary slip, details of the spouse of respondent number 1, she is drawing gross salary as a government employee to the tune of rupees 58,106 and the net salary is 52,720. As per the applicable law, it's important that the employee must maintain a gratuity and provident fund account, your lordship. But there is no mention in the election affidavit about this gratuity and provident fund account also, Your Lordship. And there is an information, Your Lordship, on page number 28, para E, that they are using a Maruti Gypsy bearing registration number ML059904. But they have not mentioned it, Your Lordship.
Okay, next point.
Next point, Lordship, the para F, Your Lordship. Under the gross total value movable assets of 7A, the amount of rupees 1,87,470 under the category of self and the under the category of wife, that is also understated, Lordship, as per the assets which are disclosed in the public domain, Your Lordship. Now, if I come, Lordship, directly to the page number 29, Your Lordship, they have mentioned in the last affidavit, Your Lordship, that there is a last affidavit 2018, Your Lordship, that there is a KCC loan of 60,000 rupees. But for this KCC loan, Your Lordship,
what's the KCC loan?
It is a Kisan credit card loan, Your Lordship. For that, one must have either some agriculture property or something related to agricultural activities. So, on the basis of that, that loan can be. But here, he has not, neither in his 2018 affidavit nor in his 2023 affidavit, he disclosed any such immovable property. So, either he has concealed this thing or he has wrongly obtained. There are only two logical conclusions we can draw, Your Lordship.
Okay, the next point.
Next point, Your Lordship, on page number 30, Your Lordship.
Yes.
Again, Your Lordship, he has mentioned his account too, but he concealed again, there is another account, that is a loan account. He has not mentioned this loan account in his affidavit.
Okay. Will this be suppression or just furnishing for incomplete information?
Lordship, as per my understanding and the various judgment of the courts, it means that it is a substantial concealment, Your Lordship. Concealment, this is one thing, and that is also of substantial nature.
Not a question of incomplete information.
Even if it is incomplete, Lordship, for the sake of...
what will be the effect?
Yes, even if it is incomplete information, Lordship, as per the judgments, this amounts to...
Concealment.
Yes, Your Lordship.
Okay, next point.
Next point, Lordship. Yes, Your Lordship. Page number 31, paragraph number 25, Lordship. The corresponding detail furnished by the respondent number 1 in para 9 of his affidavit dated so and so. The details of profession or occupation self-employed, and the wife is a Meghalaya government employee, staff nurse in the Department of Health. Now, my submission is, Lordship, in absence of exact information about the nature of self-employment, this information seriously lacks, Your Lordship, the element of certainty. If there is no certainty, the information he is furnishing, that abridge the right of the electorate, Your Lordship.
So, okay. So you say social media accounts, as you put here,
yes,
PAN card not disclosed, pending criminal case,
G,
agricultural lands,
G,
spouse assets,
G,
then the loan account,
G.
So anyway, so we'll issue notice then. Yes.
Much obliged, my Lordship.
Right. What's your name?
I'm Devendra Sharma, Your Lordship, and the brief holder counsel is Mr. Tenzing.
Just pass out.
Much
3
obliged.
weeks. Much returnable. We'll take steps within this week.
Item number 4.
What is the report?
Amit, this is Your Lordship. Lordship, I have the instruction with me, Your Lordship. Before I hand over this file, Your Lordship, may I submit, Your Lordship? Lordship, kindly come to page 41 of the writ petition. So far, this FIR is concerned, Your Lordship. A case has been registered. That is,
See, Mr. Shulai, we're not interested. We're just interested that rule of law should be maintained. That's all. That no one should just go and start and blasting and breaking schools. That's the only thing.
That, Your Lordship.
That's the only thing. We're not looking at any other aspect. Yes.
Because there is an allegation, Your Lordship, that this FIR had not been acted, Your Lordship.
No, that's not being acted. It's just that their allegation is that in spite of lodging FIRs, he has been registered. When these people came, they destroyed the school. No one did
No, Your
anything.
Lordship. Then what happened, Your Lordship? Then what happened? There is also a counter FIR, Your Lordship, to which a proceeding under 107 CRPC has been drawn and has been forwarded to the court of the executive magistrate, Your Lordship. 2 cases under 107.
What does the counter FIR say?
My lord,
Our
we have
Lordship,
no
that-
knowledge about it, my lord. And this is very unfortunate, my lord. People who have came and destroyed, and on behalf of FIR has been filed, and that has been
This one,
entertained
Your
by
Lordship,
the
this is the
state, my
counter FIR, Your Lordship.
Instead, they have not acted upon our FIR, my lord.
Let him finish, Your Lordship.
No. You don't have to act so hurt. It's okay. Continue.
Lordship, this is FIR, Your Lordship, filed by this Prangstawel one car, Your Lordship, against this Kitbor Mukim, this Sardar of Maulai village, then Klim Kamling Singh Mukim, Your Lordship, against her. So what happened, Your Lordship? This also has been registered as a non-FIR number 2 of 2023. This also has been forwarded to the Court of the Executive Magistrate at Shillong, Your Lordship.
Let's see the FIR. Have they been called?
My lord, no.
Then, Lordship, in that Modern Thing 32, Your Lordship, both the parties have been called, Your Lordship. To the accused, Your Lordship, a notice under 41 CRPC has
Which
been...
accused?
Lordship, this Prangwell and Dap, Prangstawel, Wankar and Dap Shalai, Lordship. These have been called, a notice under section 41 CRPC has been issued. They have come, they have given the statement also, Your Lordship. Everything are here, Your Lordship, because Your Lordship...
Then why did they go and destroy the school? Why didn't the police do anything?
Lordship, what happened, Your Lordship? There is a claim, Your Lordship. In 2013, as per the documents available collected by the police so far, Your Lordship, a certain part of that land, Your Lordship, has been allotted by the village Dorbar to the Maukarau Sport Club, Your Lordship.
Fine, then go for a civil proceeding. Should you go and break a school that's being erected after it's been given grants by the government?
Lordship? Then what happened, Your Lordship? Villagers, Your Lordship, villagers around, numbering around...
You apprehend them, you put them behind bars.
Lordship, can you have a look at this, Your Lordship?
Let's see the report.
Then
You can't go and see, you can't take the law into your own hands. So it might be any kind of dispute is there, and if the police have been informed and they're there and they allowed some people to go and break the schools and break.
It is not that the police are not doing their job, Your Lordship. They are doing their
It
job.
shows very well if the building's been destroyed, they're not doing their job.
Entire incident took place.
Then what happened, Your
That is
Lordship?
also twice.
Even these people, Your Lordship, these people also they have submitted an objection to this aim of hiring also, Your Lordship. This Frankster and
Then let them follow the remedy. Why they've gone for remedy? They've gone to this aim, challenging the Sorda's allocation of land. Well and good. Do it, but then you don't go, and if this act continues, that they shall be there should be no. Listen, Mr. Shulai.
Lordship,
I've noticed that whenever the court's talking, you talk alongside.
I'm sorry, Your Lordship.
You please listen. You're not getting what the court's trying to say. What the court says, this petition been brought for this court, is just that rule of law should prevail.
Certainly, Your
So you're
Lordship.
saying that they have gone and filed a complaint. Who cares about a complaint? They let them follow the complaint.
No, Your Lordship.
We're not interfering with that complaint. You think we're interfering with the complaint that's been filed with
FIR, counter FIR, then step taken, Your Lordship.
Don't throw smoke
Been drawn.
Don't throw smoke screens to protect the police, that's all.
FIR has been drawn.
This is very disconcerting.
Lordship,
If a FIR has been filed, and if they've gone to this aim, that's their business. They pursue a remedy. It's a civil dispute. If one portion of the land has been allocated to some sports club, that's fine. But can just a body of persons take the law into their own hands? Please listen.
It cannot.
Can they go and destroy and the police not do anything? That's the exact complaint they have before this court. That's all. We're concerned with that.
If Lordship allowed me to make a submission, Your Lordship. What happened? The concern here of these people, Your Lordship, as per the record, Your Lordship, it appears, Your Lordship, what happened, Your Lordship, they are against they want that the acting Sardar, Your Lordship, to convene a meeting.
Let them take the remedy. We're not bothered about. Please do not make no submissions. We're not bothered about that. Let them go whatever remedy.
I'm making the submission, Your Lordship, on the basis of what is there in the record.
You call us the police tomorrow. You understand, yesterday the court made it very clear. We don't want anybody going breaking heads and breaking buildings, that's all. What is this? I can't make out head or tail.
Lordship, there are those which I have flagged, Your Lordship. Those part are relevant, Your Lordship.
This is actually a village has decided they've given land, school being set up now for over 2 years,
Lordship,
and one fine day
Lordship, it appears, Your Lordship, from this, Your
No,
Lordship,
and
that
no
it is
appearance.
it appears, Your Lordship, the people of the village, they are not aware of that, Your Lordship. It is, it is the doing of what personally, Your Lordship. No, I'm making a submission on the basis of what is there in the record, Your Lordship.
Have you been called with regard to other FIR filed by them?
I am yet to confirm, my lord. And my lord, may kindly see, my lord, the
You file affidavit, bring the status and what have you done to these people who have broken the school. That's all. Mr. N.D. Shulai, London AAG, has produced some papers purportedly showing the action taken by the police in this regard. Stop. He is directed to file an affidavit highlighting the relevant points, aspects of what has been done after the FIR has been filed with regard to the disruption, with regard to disturbance caused by certain elements in the village, which has resulted even in the destruction of the construction which is being undertaken. Stop. It is made clear that this court is not delving into other issues with regard to as to whether there's a civil dispute or whether other recourse to other civil remedies has been taken by the parties concerned, but will only look into the aspect of the maintenance of the rule of law and the steps that the police should take in such situations. After we file within a week, we file it.
May I further submit, Your Lordship?
It is expected that it is expected that the security should be maintained in the area and no untoward incident should be reported.
Yes.
May I further submit, Your
Yes.
Lordship? Lordship, in fact, this matter can be sorted out, Your Lordship.
Then sorted out.
Your Lordship, if Lordship allowed me, just 1 minute, Your Lordship, if these
I'm very disappointed with Shulai with you. I've been making submission. Why are you making submission on behalf of people?
No, Lordship.
Are you holding their brief?
No. I'm making submission based on this.
I'm holding their
record,
brief. They've gone to CM.
No,
then you engage your junior. Go off
on the basis of the record, Your Lordship. In fact, Your Lordship, this matter can be sorted out if these people
file affidavit.
If these people are called, Your Lordship, before they are this
call, they'll be apprehended.
It can be sorted out, Your Lordship. This problem can be sorted
out. Law will
out.
take its course, Mr. Shulai.
5.
I don't get. This court doesn't really lose go, but then the way submissions are going different, they've gone to the CM. Let them go. That's a lawful remedy. If they have any grievance, any allotting land, let them go. Let them file a suit.
In fact, it can
let
be
them
sorted out.
Let's seek injunction.
In fact, it can be sorted out, Your Lordship. It can be sorted out, Your Lordship.
Let them do it.
If these people are called, Your Lordship, they can be sorted out.
They should be sorted out, not them sorted out.
It seems the CM is not doing his job, Your Lordship. Okay, Your Lordship.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, this case is with regard to settlement of fishery known as Borovilla fishery, Your Lordship. Your Lordship, here I am challenging the order passed by the executive member. Your Lordship, earlier also there were petitions.
Where's the in order?
Your Lordship, in page 30, Your Lordship. As per this order, Your Lordship, the fishery was settled between the respondent number 4 and respondent number 5. And Your Lordship, as per the order dated 2/9/2022 of this Honourable High Court, Your Lordship, passed in WPC number 427/2020, the settlement of the fishery was supposed to be conducted afresh. That means by floating the tender, Your Lordship. But however, in this regard, Your Lordship, no tender was floated by the respondent's authority, and they have just settled the fishery. And as per this Annexure 11, Your Lordship,
Okay, this is order was passed on.
order
2/9.
was passed on 2/9.
Then this impugn order was passed on
12/9/2000. It's not
legible.
legible, Your
12/9.
Lordship.
Okay.
I suppose it's 22.
No, it's 12/9. Is that correct, Mr. D?
12/9. But the year is not legible.
So there was a compromise between the
Parties.
Mr. Mozika and Mr. Paul.
Yes, my lord. And we have divided.
Their client.
Interestingly, my lord, here the petitioner, what locus he has to challenge this order. First and foremost, my lord, I want to point out.
No, yes, well, let her finish. Now, Mr. Rafsar, what is your, on what basis are you?
Your Lordship, even I have.
You see, it's gone beyond the settlement period. That they should be fresh tendering for this fishery.
Yes, Your Lordship.
This period settlement will lapse when?
That I have to
From
take
the
the
earliest
instruction.
tender.
That I have to take the instruction. But my submission at this point, my lord, is this. These are certain official documents. It appears, my lord, here, the person who is about to complete has asked someone to file this petition. It appears, my lord.
Who was asked to?
The person whose term is going to be, just let me finish. You have completed. Let me complete, my lord. The person, Kunal Koch, my lord. The person, the first beneficiary, it appears he has asked a petitioner to approach this honorable.
He's enjoying it now.
Yes, because his tenure is going to be over in the month of July, my lord. So he won a tender to be floated, my lord. Probably he will participate. Now, my lord, interestingly, the annexures, these are all official documents. The petitioner has not disclosed anything in the writ petition how he has obtained these documents, my lord. Nothing has been mentioned. Second thing, my lord, petitioner has also not said, my lord, anywhere in the writ petition that he is interested to participate. Let the petitioner show a averment made that if tender is floated, I will participate. There is no such averment, my lord.
So this is surrogate litigation.
I feel, my
I
lord.
have stated, Your Lordship, in para 20.
Yes. Very clever. Yes. What is it?
In para 20, Your Lordship, I have stated that that the petitioner state that the fishery rules mandate for notice inviting bid calling the applicant for the sale of registered fishery. It is also a mandate that the said notice shall be issued not later than the 15th February of the year expiring the lease period. When no such notice with regard to the sale of Borobila fishery was issued within due date in the first week of March 2023, the petitioner approached to the respondent authorities and asked for the date for tender notice. On being inquired, the petitioner came to know about the impugned internal arrangement between the official respondent and the private respondent 4 and 5, Your Lordship.
So where is the averment made that he is interested to participate in the tender? So where is the averment, my lord? And we have, my lord, that settlement was made as per the order of this honorable court, my lord. There was a claim and counterclaim, my lord. A liberty was given to us to take a fresh call, my lord.
Yes, they are the owners of the asset. I mean, they can. You will issue notice.
Your Lordship.
Let's see what those private respondents have to say. Yes. Heard MS Kasano, the council petitioner, issue notice returnable in 3 weeks. Mr. SD is present on behalf of the respondents.
1, 2, and 3.
1, 2, and 3, no further notice called for. Petitioner takes step issue notice on the remaining respondents within 3 days. List of the 3 weeks. Yes.
Your Lordship. Highly obliged.
Item number 6.
We are in the process of filing the affidavit, Lordship. We have already served the advance copy to them.
Should we go through this affidavit? This has nothing to do with the cause of action.
That's it.
So they're referring to the minutes of a particular meeting held on the 6th of December.
Lordship, the notice, Lordship says that within 15 days, Lordship.
So that's okay. We're not going to remove them.
Let the
There
affidavit
is already an
come.
order
Just take it
from
after
the
some time. Yes. We take it after some time. Let the affidavit come on board. We'll close it, Mr. Chanda.
Mr. Paul will
You
be
have recourse to other remedies. What you came for and what is now is the situation is totally changed.
Lordship, the very proceeding emanated from the PP proceedings, Lordship.
The whole thing has changed now. The whole situation has changed. You're not in danger of dispossession. I mean illegal dispossession, yes.
Main list, item number 1.
Yeah.
Your Lordship, we have filed the application. We have filed the application, Your Lordship.
What?
Impleading a defendant, additional defendants.
The
According to-
Accountant General.
Yes, Your Lordship.
Where's the petition? Okay. 31. Yes, Miss case number 31, 23, WPC number 58. So there's an application for impleadment of the Accountant General Meghalaya, Shillong, as respondent number 4. So, seen the grounds may not therein. It appears that there respondent force the Accountant General as a party. Accordingly, the misapplication is allowed for impleadment, and the Accountant General Meghalaya is implead respondent number 4. So, this to make corrections in the main application. This case is disposed of. Now the main case into the order passed in this case also. Issue notice to the respondent number 4 within 3 days. This matter up to 2 weeks.
And your Lordship.
Item number 2.
Well, I pray that this matter may please be taken next week. I need some instructions from the client, so.
You file review.
If it could come.
Oh, you're a review petitioner, Mr. Siddiqui. Yes.
Yes, I'm the petitioner.
After 1 week to allow, the review petitioner to obtain the instructions.
Review petitioner?
Oh, sorry, petitioner. What am I talking about? Yes.
3.
Please, Lordship.
Yes.
Lordship, this is the case where the petitioner is the present Nokma of the particular argument. The fact of the case, Lordship, that.
Why is this admission today, Mr. Soma?
Lordship, this is because I have filed challenged the order of the CEM, whereby the CEM, there was a direction from this court to file an application for seeking the continuation of delay, and an order has been passed by this court to file an application for continuation of delay, and accordingly the matter should be decided. That was the order, and instead of doing that, Lordship, what happened? There is no application, separate application has been filed by the present respondent, and the EM also very clearly indicated that there was a delay, and delay has not been explained. However, due to the ignorance of the respondent, this should not be suffered, and they have just condoned, which is a clear violation of this. Your Lordship, I prior to that, let me just come to this admission.
So let's see the part where he condoned without any application.
Lordship,
application was filed, my lord. Even last occasion.
Lordship, let me just before coming to that, I want to submit the conduct of the petitioner, because this, if we go by to the annexure, Lordship, page 27 of my page 26 of my petition, the order, I will just highlight what happened, Your Lordship. My 4 parents, and I'm the daughter and son-in-law of the not my Lordship, and in the year of 2007, we have filed an application to register the NOCMA, Your Lordship, and our application for registration of NOCMA was rejected by the predecessor of the present respondent. Now, my Lord, if we go the page 26, which I would like to submit to Lordship, after filing an objection, they never appear before the court. They never appear before the court, and they have abandoned the case. And opportunities was given to the petitioner for the objector, but never turn up to the court, Your Lordship. It is reflected in the order that may I take you to the annexure, the page 26, type copy, page 26 of my petition. I will just read this third para where it is very clearly reflected. Your Lordship, the Srimati Kangsi Armarak, that is the present private respondent, has filed an objection to the petition of Sri Kiving Armarak, subsequently in the court of trial of the case. The objector, Srimati Kangsi Armarak, remained absent for many days, Lordship, many days,
Yes, okay.
without taking any step, as is recorded in the order sheet of the case, though sufficient chance and opportunities were given to her. Finally, objector Sri Kangsi Armarak has abandoned her case, and she did not contest. This court, therefore, ex parte hearing of the case, petitioner has filed written argument, formally in respect, written statement, Lordship, I'm sorry, formally in the respect of the right of the elected NOCMA, Sri Division Jimuman, and his wife, Nalini Armarak, as submit and suggested issue also to this court. Lordship, what I'm trying to say from the record is they have been continuously neglecting since from 2007.
Okay, read.
Then thereafter, Your Lordship, I will complete the order also.
Yes.
I have pursued the record, document available in the record, including the report of the Mozandar, the suggestive issue submitted by the petitioner duly considered. The main issue for determination are whether the person whom the petitioner has claimed to have been elected by the Mahari as NOCMA of Wakso Akeng were legal heir of the last recorded Akeng NOCMA of Wakso Akeng. The answer to the question is that person concerned Sri Devinson G. Moman and his wife Nalini Armarak are the legal heir, and they have been lawfully elected by the Akeng Mahari according to the Garu customary law, as they are the Nokrom son-in-law and the NOCMA daughter of last recorded NOCMA of Wakso Akeng number so and so. This court is therefore considered view that Sri Devilingson G. Moman and his wife Nalini Armarak are the rightful claim for NOCMAship of Wakso Akeng. I therefore declare them as a NOCMA of Wakso Akeng. The name of Srimati Devilingson G. Moman and his wife Nalini Armarak be registered as NOCMA of Wakso Akeng, and their name be entered in the GT of Wakso Akeng accordingly. Now, my lord, this order was very clear that they have followed all the procedure, they have framed the issues.
Okay, then what happened after
Then
that?
after that, this order, they have challenged this order before the CEM, Your Lordship. That's the next page, Your Lordship. Here also, Your Lordship, I may take you to the type copy, the annexure, no, page 31. Page 31. That is the tape. Here also, they file an appeal in time. Now, Your Lordship, you can see this one. The case record put up today, appellant and their counsel also absent without taking any step. Again, Lordship, the record shows that the appellant have not yet paid the adjournment cost of rupees 200 only also, though the case is fixed for argument today, since the appellant themselves have failed to turn up to argue the case without any just and sufficient cause. This court considered that case could not continue because of the repeated default of the appellant themselves. The appellant appeal is therefore dismissed, and the order of the lower court is hereby upheld. The name of the elected new NOCMA, and which Sri Dwellingson G. Moman and his wife Srimati Nalini Armarak be registered and recognized as holder of the lineage EM, IC, Revenue, JHTC, and their name be entered in GT as Wakso Akeng. As the pending adjournment of cost rupees 200 only, aggrieved party may take appropriate step in different proceeding if desired. And here also, Lordship, we found that they have abandoned the case. They are not at all interested. They file an appeal appeal is submitted. However, it is from the record, Lordship, I no need to explain, it is there on the record. They have completely that means most neglecting, they have neglected the case. They are neglecting the case, and against this order, Your Lordship, they have come to the High Court, Your Lordship. The High Court order, Lordship, this is the Lordship from this court on Your Lordship. This is the order passed by Your Lordship, where it is very clearly stated. May I read? Some very strong observation also has been made in this order, Your Lordship. May I read, Your Lordship? The para 1. The appeal, the pleaded case of the petitioner are that they are the sisters.
Okay, Mr. Sangmajesty, the operative part.
The operative part, Your Lordship, may I come to the para 6. Okay. There is a direction. Before that also, strong observation has been made against them. It is there in the record. I will just the operative part of the order, the para 6, page 35. I have given my thoughtful consideration to the fact and circumstances of the case and reason which have been ascribed by the petitioner to explain the latches and lapse. Normally, petition like this would not be entertained and would deserve no consideration. However, in the instant case, considering the situation of the petitioner, who is illiterate and interest of justice, in spite of the fact that much time has been elapsed since passing of the impute order, the writ petitioner is permitted to go before the Chief Executive Member JHDC by way of an application seeking continuation for delay and seek for record of the order dated 12 March 2010 for rehearing of the appeal. The Chief Executive Member in this direction shall examine the same on each merit and pass an order thereon. It is made clear that impugn order here shall not be disturbed till the proceedings are finally conducted. Concluded. It is concluded. It is further made clear that this case will not serve as a precedent in the similar matter. Your Lordship.
Who has the order of the?
Now, as per this order, Your Lordship, this matter was remanded to the.
Who has the order of the CM then?
Now, Lordship, no, before that, let me come. Line by line, Lordship.
Line by line, okay.
Because they are jumping, Lordship. Because it has to be detailed, Lordship.
No one should jump
the annexure 5, Lordship. After passing of this order, now the CM, the direction was clear. They're supposed to file an application for good reason of delay. That direction is there. Now, what happened to the CEM? Instead of following the High Court order, the other order has been passed, which is contradicting and which is not even related to this. And they have even withdrawn also, Lordship. The page 36, Lordship, annexure 5. See, Lordship, they have passed this order, seen the petition which was filed so and so, Justice Marab, who is the affiliate in the miscase number so and so. Now here in this case, instead of let's just complete praying allowed to issue notice Nokma document to the resident of Wakso Akung who are the facing difficulties due to non-issue of Nokma document, pursue the record of the order of the Honorable High Court order dated 09/07/2019 in WPC so and so, the after which it hereby directed that the status quo will be maintained by both the parties till the disposal of the appeal before the court. Considering the present situation and the problem faced by the resident of Baksokang, it is directed that only for the purpose of birth certificate, case certificate, job card, PPL, small matter, which does not include the asset of transfer of land in Akung, Simiti Jersey or Marak will be allowed to issue Nokma document and not more until the final disposal of the case. Now this they have passed.
Okay, that is over.
Yes, Lordship. This is over and then they have to withdraw this case.
Come to the impugn order.
Now impugn order. After this case, since they have withdrawn, then the Lordship has passed an order that was disposed of. We filed we challenged this order also, and this order was stayed. And then finally, at the final hearing, they filed an affidavit. They have withdrawn that order, Lordship.
Now the impugn
order. Now the impugn order, Lordship. This is the page 14, the annexure 8. Annexure 8.
Yes.
Page 46, Lordship. Now they have stated many things, but I just need to read the relevant portion of para 4, 5, 6, 7, 8 to till the following, Lordship. See. Just read. I just like to read para 4. Following the order of the High Court, the affiliate through their lawyer, had filed an appeal petition on 4th August 2019 only with a prayer to admit their appeal by way of application for continuation for delay and recall the order dated 12/3/2010. The council appellant failed to file separate petition for continuation of delay, and no indication how many days had been delayed, which needed to be condoned. Nothing had been mentioned in this petition. He also failed to file petition to recall the order dated 12/03/2010 passed by the CEM in spite of clear direction by the Honorable High Court in its order dated 09/07/2019. However, while appeal petition is pending for hearing, then the CEM on application by the present appellant passed an order dated 13/10/2022 without any hearing and allow the appellant to issue NOCMA document for obtaining birth certificate, caste certificate, BPL, etc. Against this order, present respondent filed a writ petition before the Honorable Court. Subsequently, the then CEM had filed affidavit by recalling his order dated 13/10/2022 and the Honorable Court in its order dated.
Okay, Mr. Sangma, just to cut short things.
Yes.
The court has seen this order.
Yes.
Now, the only thing is that court, this CM observed that they did not file correction application, they did not file a petition for recall of the order, they file a fresh misappeal, which is not necessary. If recall of order, that means earlier, if it's allowed, the earlier appeal memo will stand revived. Correct. But they said that fine, overlooking all these things, they permitted to file a fresh petition for recall of the order. Doesn't mean it's been allowed. So your prayer that it should not be allowed this also. That's enough is enough. That is your prayer.
Yes, Lordship. Because see the conduct
Yes,
of
Mr.
the
Bowman,
nature.
This conduct
Since from
this-
2010.
yes. No, let the private respondent. This conduct is, I think, it can't be condoned any further. The specific orders were there. You can file condemnation for recall, file condemnation application, and file an application for recall of the order 2010. He did neither of that. He filed a fresh appeal.
Application was filed, my lord. An application of
address this on
1 second, yes. Was it filed?
Yes, my lord.
Then it's not reflected in the order.
No,
We're going by what the impugn order, what it says.
No, my lord. If I can point out, my lord, they have filed a miss case, my lord, a miss appeal number so and so, and the respondent has filed, and they have stated, my lord, that an application by the applicant seeking condonation for the delay and for recalling of the order dated so and so, and for hearing the appeal as directed by the Honorable High Court of Meghalaya, Shillong. Now, my lord, a separate miss case was not filed for delay, condoning the delay, my lord. That was not done, my lord. But
Exactly.
in this petition, they have done this two things, my lord. Even they have prayed for recalling the order and also for condoning the delay in this application. Well, there is an application, original copy of the application.
You didn't annex a copy of the file by them?
It's not given to me, Lordship. I was not there. However, Lordship, even if they file also, they have very clearly they have not mentioned how many days. The limitation, section 5 to the limitation, very clear, Lordship.
One application, everything is done.
Everything is, my lord.
Yes,
That is not, my lord, what can be appreciated, but the lawyer should have at least, my lord, done his homework, my lord, properly.
And this is not.
See the
first
cause
time.
title.
Yes, my lord. It's very unfortunate because, my lord, the private respondent, I'm not arguing on behalf of him, my lord. But here, my lord, again, they are the villagers. The lawyer
See,
should have guided
the
them. my lord,
consideration that this court had given earlier on is because of the literacy and
Yes.
so fine, like, they were allowed to file and, file an application which is specifically, if they can't follow orders of the court, I'm sorry, Mr. Moomin, I think.
And they take advantage because every time court has so much lenient on them, they take advantage, Lordship. This is not the first time. Right from 2010,
My lord, here,
While
during the
filing against
discussion,
the EM also.
my lord, if my lord come to page 35, the order of this honorable court only, my lord. My lord, discussion was given to the CEM to decide, my lord, and whether to
To
condone or
decide,
not.
no, not condemnation. Condemnation is one thing, recall of order is another thing also.
Yes, my lord. Yes.
So that is that he has decided on
My
on two
humble prayer,
aspects.
my lord. My humble prayer before this honorable court, my lord, as there was an application, my lord. It's not that there was nothing before the CEM, and he has done on his own, my lord. There was something, my lord, and he has imposed cost also. It's not that, my lord.
No, see, what does he say? He says that he is not satisfied with the petition.
Yes.
He says that you filed an application for recall of the order, has not been filed.
He is not considering this, my lord, because this is a mixture of two things.
If he didn't, can this court consider it?
No, my lord. That is for
Yes,
the...
Mr. Moman, what do you have to say?
And cost was imposed, my lord, upon the petitioner because
So,
of
of course, very good. Will cause the curative effect.
No, it will not, my lord.
That,
This is normal.
what should we do?
Lordship, well, last chance may be granted.
No,
to the
because they
petitioner,
have
so
last
the
chance they have been
respondent
giving
might
last
say that,
chance from
application may be
2010,
filed,
right from
because-
the code of EM.
Kindly let me make my submission. We have already made a submission. Lordship, at least last chance may be granted so that at least an application condonation may be filed, my lord. Delay and leave it to the discretion of the CM, my lord. Because of the fault of the lawyer, my lord, the
File a small
responsible.
affidavit
Every
within 1
time
week.
they cannot blame the lawyers.
Will pass out.
Lordship,
Last time you blamed matter has been heard. However, only sorry for you. Just bring on record that application.
I will bring this.
Yes, Mr. SD is permitted to bring on record the application, the appeal filed by the respond before the CM before the next year, at least of 2 weeks. Just file an application. Because we have to take judicial notice of that. Yes.
Item number 4.
Hello.
Yes.
Lordship, by the order dated 14 March 2023, the Lordship had directed us to pay the amount of rupees 15,000 towards Meghalaya State Legal Service Authority. That has been complied with on 13th of April, my lord. I had paid it in cash. The receipt is with me and submitted in the court. Secondly, my lord, in this particular matter, the respondents have been praying for time to file affidavit time and again. The writ appeal prepared by the respondents, the contemners, was dismissed on 10th of October 2022. 6 months period has already elapsed, my lord, whereas by judgment dated 13/3/2020, this honorable court had directed that the judgment should be complied with within a period of 3 months, my lord. So this is amounting to willful and deliberate violation of the order passed by this honorable court. Page 12 is the judgment, my lord. Respective portion, para 11.
But my suggestion is that they were exploring the possibility of filing SLP, but now that has been, they're not filing an SLP and they're in the process of complying with the order, my lord. So some more time is required for that, my lord.
We file affidavit saying you're complying with the order. You're saying they're complying with the order.
Otherwise, my statement can be recorded, matter can be closed, my lord. By giving us 2 months time, my lord, we'll comply within this time.
We can't grant time. It's as per the earlier order. Where's the order? Page?
Page 12, my lord. Para 11.
Page?
Page 12.
10 or 12? 12.
12.
Yes.
Paragraph 11.
Yes, take down. MSP Agarwal submits that the amount has since been made over to Legal Services Authority by cash on, when did you?
13/4.
On 13/4/2023 stock. She further submits that in spite of numerous chances, numerous opportunities being allowed to the respondents, the affidavit, the affidavit is still yet to be filed. Stop. She prays that contempt proceedings be instituted against the respondents in this regard. Stop. Next paragraph. Dr. N. Mozika submits that the non-filing of the affidavit in time was due to the fact that the respondents were exploring the possibility of preferring an SLP before the Supreme Court, which, however, has now been abandoned. He therefore submits that the order is in the midst of being complied with, and the same should be completed within 2 months from today. So what to do? Yes, sir, for 2 months. In view of the submissions, the matter is closed at this stage, giving liberty to the petitioner to issue fresh, to institute fresh proceedings if the same not complied with.
Malo. Please oblige, Malo.
5.
Yes, Mr. Basumatari.
May I please, Your Lordship, we further need 2 weeks' time to file the rejoinder.
Rejoinder to what?
To the
What affidavit you filed?
There was an additional affidavit which was
By you?
filed by the government.
Regarding?
To
School.
bring certain, yes, to bring certain facts on record.
How many times you've asked?
Just once.
Once.
There's just one more time we'll give. 2 weeks further time granted to the petitioner to file a joinder affidavit additional, to file a joinder to the additional affidavit filed by the state respondents. Yes, after 2 weeks, yes.
6.
Oblige, Your Lordship.
I'm not on board, anyway.
Petitioner has received the check.
On 31st March.
This is a contempt, so we'll close it.
Yeah, man.
This party submit that nothing survives consideration in this matter. Contempt outline closed. Yes.
7.
Who's appearing for the, what's the matter about?
This is about, my lord, some demarcation, my lord. Spot inquiry and all.
Yes, none appears. We have the petitioner. Filing the joinder is closed. It's a matter for hearing.
My lord, after 4 weeks.
After 4 weeks.
8.
May I please, Your Lordship? Your Lordship, I feel further weeks may be allowed Your Lordship to file a rejoinder.
How much time have we taken? How many times?
Once, Your Lordship. Once.
We just give it one more time. It's 2 weeks time. 2 weeks for the time allowed for rejoinder.
9.
May I please, Your Lordship? This is pertaining to the case of gratitude. Since the petitioner have received all the money, I would like to withdraw from this case, Your Lordship.
She received.
My lord, I have a serious objection on this, my lord. Why? Let there be a proper hearing in this matter, my lord. They have misled this honorable court and issued a notice of this honorable court. We find, my lord, that the money was withdrawn. Subsequently, they filed a writ petition, my lord.
The money was withdrawn, Your Lordship. I have enclosed in that one, but can you check my annexure, Your Lordship? Annexure number 2, page number 9. And this annexure, it is clearly stated that rupees 10 lakhs, which amount to the gratitude, Your Lordship. And in that one, annexure number 3, page number 11. In the succession certificate, in the succession also, it is clearly mentioned that in the gratitude amount is rupees 10 lakhs. But after going through the affidavit, which was filed by the respondent, page number 10, annexure number 1, it is clearly mentioned that they have already got the money, Your Lordship.
My lord, here, my lord, may kindly see page 9, what my learned friend was referring to.
1 second. Why? I don't understand. Why did you file the case then?
Well, money was already withdrawn, my lord. Subsequently, they came, my lord, here. And from where this document they have manufactured, my lord? We don't know. This was never issued by us, my lord.
It was issued from the from the account office, Your Honor, finance department.
This was never issued, my lord. This is
And
not a part of our record, my lord.
And from the judicial, from the GSTDC, Judicial Officer, Additional District and Session Court, GSTDC, they have already obtained that one success certificate on 1st September 2021.
Ms. Sangma, the thing is, he has made some objections.
Yes, Your Honor.
What amount have you actually drawn?
It was 10 lakhs, Your Honor.
You've drawn it. It's
Yes,
been drawn.
according to that one, which was filed by that respondent in annex number 10, it was clearly mentioned that all the amounts, Your Honor. After going through the affidavit, my humble plea is there just to withdraw from the.
They were supposed to just my lord. Let my submission be recorded, my lord. Yeah, my lord. They were supposed to get 3,56,507, my lord, rupees.
3,34,656.
Yes.
Okay.
This much money they were supposed to get, my lord. Now they have brought a document before this honourable court. They are saying that the claim was 13,34,656 rupees, my lord. We don't know, my lord, from where they have. And based on this, my lord, the notice was issued by this honourable court.
Who's the accounts officer then? You have to take action against him.
No, my lord, here they have not mentioned that the account officer has given them.
It was.
They have not stated anything, my lord, that the account officer has
Seal
given
also
them.
is there, Your Honor.
Still, my lord, can we manufacture?
Seal is also there,
So anyway,
and the signature
take
also
down,
is there.
take down MSA Sangma today, when the matter is being taken up, submits that they don't wish the precedent petition in view of the fact that the petitioner has already withdrawn the gratuity amounts as admissible. Stop. Next paragraph, Mr. SD, Learned Counsel for respondents number.
All the respondents.
All the respondents has voiced strong objections to the submissions in view of the fact that the document annexed to the writ petition at Annexure
Annexure 2, page 9.
Annexure 2, Annexure 2, page 9 is of unknown origin, which he unknown origin, as it is not known, as it does not reveal as who is the issuing authority.
And annexure
Only
number
apart
3,
from the
page
fact
11
that
also, Your Honor.
there's a seal certifying the same by the in charge accounts officer, Finance Department GST 2. So, what else?
Annexure number 3, page number 11, in the succession certificate also, it is clearly mentioned that gratitude amount is rupees 10 lakhs.
Yes, so that's not certificate, my lord, as per their claim only, my lord.
That's in.
Now, my lord, my point is this, my lord. Yeah. The money which they have withdrawn in 9/12/2021. If my lord may kindly see page 11 of my affidavit.
Yes, no, that's it. He further submits that the gratuity as entitled has been drawn on
9/12/2021.
2021 before the writ petitioner approached this court.
And writ petitioner has approached this honourable court
on 9/9/2020. Yes, which approached court on 9 and 22, which is highly irregular and amounts to suppression and misleading the court stuff. Next paragraph. Have you heard the counsel for the parties the facts and after hearing submission of the parties, acknowledging the fact that the gratuity amount has since been paid. With regard to the other incidental proceedings or the veracity of the documents, the respondents are to pursue, are to take up the matter internally. That matter calling stands closed. Internally in accordance with law. Yes, matters calling stands closed. Disposed. See, Mr. Day, it's not only case. Many cases got from district council. Even the earlier case, fishery also, where they produce the.
Yes,
see, it's how the office is run. That's all. Yes, Mr. Sheikh.
But as far as state affidavit is concerned, we are filing it today.
You filed it.
Not I've served the
Mr. Hassan. You filed.
Yes, my lord, the earlier headmaster has already filed the counter. Yeah, I don't know what, and he has filed one affidavit to bring on record. And government in the counter has already admitted that there was.
He is headmaster.
He's headmaster.
So what remains for him?
My lord, as per the order of the SDSCO, I am the present headmaster, in charge.
That's all right. No quarrel about that anymore.
Government, as per the affidavit, they admitted that there was.
So what remains? So what we do matter today?
My lord, because the term is going to expire in July. So since the approval was not in accordance with law, because parents and guardians were not there, so direction may be given to convene as per the.
Lord, if that is so, my lord.
Now let's see.
Affidavit, my lord. Yesterday I could not file it because I could not.
Where's the affidavit?
Affidavit is here, my lord. So let the matter come up tomorrow.
Mr. Kibar he submits that. Praise him not to file affidavit in the course of the day. Surprise on this after 1 week. I thought the affidavit is already on board.
11.
I wanted to file it, my lord, but since I could not.
Respondents were supposed to file affidavit, lordship.
My lord, I appear here on behalf of respondent number 1 to 4 state respondent. My lord, may kindly give me some more time. We have received instruction, my lord, we will be filing in
2 weeks for the time granted to the respondents to respond to file affidavit. You're appearing for?
Respondent number 5 to 7, 10 to 13.
You file affidavit? You're not filing?
Waiting for some time.
What's not reflected here?
14 respondents, my lord.
14 respondents.
5 to?
7.
Mr. I. Sumer on behalf of 5 to 7. 5. What about 8 and 9?
My lord, 8, 9 and 14 has not appeared.
5 and 7, 5 to 7 and 10 to 13. Please for allowed similar time for filing affidavit stuff. None appears for respondents 8, 9 and 14. Yes.
12.
Your Lordship, I pray for the 2 weeks time you received to file my agenda.
You are paying for the school. You all file affidavits all filed. Yes, sir. Which school is this?
No, this is Hospital and Provident Fund.
Oh, sorry. Yes, 2 weeks for the time granted to the petitioner to file the joint of the affidavit filed by the respondents.
All right.
13.
I've taken steps on the respondents, my lord.
My lord, also. We are hearing for respondent number 1 and 2.
For 3. Yes.
3
1 second. Also, sorry, Mr. Chani. So, 1 second. This is 23.
1 and 2. Me and Mr. P. Nombri.
See, because election petition kicks off from your appearance. Okay, and then the proceedings, our High Court has not prescribed any specific rules. So that means we're far as wherever the CPC does not repugnant to the RP Act, then we are following we will follow the procedure of as given in the Civil Procedure Code in case of trials and suits. So anyway, yes.
My lord,
we
have followed the Guwahati High Court rules, my lord, in this matter. Because
why?
Our High Court
it's not replicated. It's not replicated.
Our High Court rule says that if the rule is silent, then Guwahati High Court rules will be followed.
No, our chief is different. He said does not bang on to Guwahati all the time. So,
because the election rules are of the Guwahati High Court rules.
Okay, then we'll see. It does. I think it is more or less parameter. I mean, with the CPC only. Yes.
My lord,
yes,
yes,
come here now.
3 is concerned.
Yes.
My lord, proper service has not been made. But we had applied for a copy from the registry. We got a copy. But as per
I was informed.
1 second. Okay. Number you're the return candidate.
Return candidate.
We was informed from the registry branch, my lord, not to take steps because the respondent council will come and collect it, my lord. We was informed that, my lord, because we have taken steps. There was no problem for us to.
Why should the office inform them?
They have informed us.
What we had done is
and we can swear an affidavit to that effect.
We supplied for a copy. But the proper procedure is that they are supposed to take steps to the normal like we normally do. Now, when we came to know that a petition has been filed, my lord, we wanted to know.
See, in steps election cases that it's the notice of summons. It's like that. So I mean, you will get the summons or notice. You should have got it formally.
My lord, formally.
But
that's what I'm saying.
It's neither his fault or your fault. It's because I think because you applied, it sort of cut short the process. You should because he doesn't know this election is election matter. So are you?
We have a copy, but my lord, the problem here is
we'll give them a copy
under 81. My lord, procedure has to be followed. Otherwise, of course, it is a
They have
technical
to-
objection.
You have to prepare summons. From
My
the
lord.
office itself.
That may be done, my lord.
Yes.
We'll do that.
And Mr. Changreso for
For 1 and 2, me and Mr. Pino Bremen.
Mr. 1 and 2, Chief Electoral Officer.
Yes, in RO.
The thing is that are you a necessary party here?
But since they have implemented in some allegations there with regard to
Against the returning officer.
Yes, so it requires some evidence from our side.
Okay, Mr. KCH Gautam, who is present in court, submits that a proper notice and summons has not been served upon the respondent number 3, though a copy of the election petition is available with him. Stop. In this regard, stop. Next one, we have to clarify this. Ms. SD, counsel for the election petitioner, submits that as the office, as they inform a registry that the respondent number 3 had applied for a copy.
No, my lord. We was informed that the respondent number 3 will come and collect it. We were supposed to post it.
And they were informed registry that as the respondent number 3 was collecting a copy, no formal step which the summons need to be taken. Stop. No, next one. It is noted that as election matter, the proper procedure as prescribed is to be adopted and followed. This matter registry is to make the necessary corrections, take necessary steps to issue formal summons, notice summons to the respondent number 3. The same shall be entered in the records. Then next paragraph, Mr. H.L. Changreso,
Mr. Pino Bremen.
Senior Counsel, assisted by Mr.
Pino Bremen.
Where I don't see no Pinongbri, assisted by SK. What's why? Arpas and team. The appearance on behalf of the respondents number 1 and 2. Yes. So now, off the record, how long will it take to file a statement?
My lord, at the moment, my lord, I can't say, my lord. Let us receive a copy.
What do you mean you can't see? You only got a copy in your hand.
No, my lord.
It's off the record, I'm saying.
Off the record.
Because you will try to expedite it.
2 or 3 weeks, my lord. Whatever steps we will take. Let's say 3 weeks, my lord. 2 weeks.
This is a matter after 3 weeks. Yes, for reinstatement, for report and service and written statement by the, but not service by the, you're going to delay it.
No, my lord, that's not the. They have a copy. I had to point out because the procedure has to be followed. Yes, obliged.
14.
Please, Your Lordship. Lordship, in this matter, I beg Lordship may list it along with the other connected matters, Lordship, on the 4th.
Why is this matter listed on its own?
Lordship.
You're supposed to list it together, correct?
Lordship. Lordship, the roadmap is still being prepared. Lordship will be filing in the course of the week. Also, I just pray that matter will come up along with the other connected matters on the 4th, which is on the 4th, Lordship.
This matter concerning payment of pension to the employees of the MECL is as this matter concerns payment of pension to the employees of the MECL. This is the same with other connected matters on
4th, Lordship.
4th of May.
4th of May, Lordship.
4th of May 2023.
15.
Your senior will be back by then?
Yes, Your Lordship.
Much obliged.
Your Lordship, in this case, I may be given some time to file my complaint. I am yet to receive instruction, Your Lordship.
So, what about the district council?
We are not. In fact, it's directed against respondent number 4.
Right. What's the matter about? It's regarding that NOC for you given NOC for the land acquisition?
No, not exactly, Lordship. There's some papers, some documents which have been addressed to this council. For that reason only we have made this council as a party. Otherwise, they are not necessary.
Mr. Ijaran, please sponsor for the 2 weeks time. That affidavit. Yes, that after and so on.
16.
Your Lordship, the respondent number 5 has already filed the affidavit in opposition, Your Lordship.
Cannot hear you. Little.
The respondent number 5 has already filed their affidavit in opposition, Your Lordship.
Yes. What about the number 1? Number 1?
They won't be filing.
File. 2 and 3?
Your Lordship, 3 is not designated position post your Lordship, so just 3. We filed our affidavit.
You said there's no designation as respondent number 2 or respondent number 3?
They said that it's respondent number 2, Your Lordship.
So you file, you have respondent number 3, you file.
Yes, Your Lordship.
It's urban affairs.
Municipal board, Your Lordship.
Yes.
Lordship, they're claiming that they are
Okay,
the
struck
legal
off.
marriage,
Number
Lordship.
2 has been struck off. So number 3, register of birth and deaths. Yes. Now for number 4, you're not filing. You're not filing.
5, I have filed it.
And number 5,
I have filed, Lordship. Is there? I found a private respondent, Lordship.
so all the affidavits are on board.
Yes,
Yes.
Your
What do you want?
Lordship, in their affidavit, they have annexed one marriage certificate, Your Lordship, which is out of this jurisdiction, Your Lordship. As the the deceased and the present private respondent got married in Jordan, Your Lordship, which is out of this jurisdiction.
I will,
Jordan?
Yes, Your Lordship.
I will reply to this because it is done as per the Indian Christian Marriage Act. Even that petitioner, they have enclosed the marriage certificate. That document is neither as per the Special Marriage Act nor as per the Indian Christian Marriage Act 1872. They have enclosed only the deed of marriage. But as per the Indian Christian Marriage Act, Section 3 is very clear. Any episcopal, the person who received the episcopal ordination, they can solemnize the marriage as per the Act, Lordship. So there is nothing wrong in that.
Is this a recognized marriage?
This is actually, Lordship, what I got it from the petitioner. But
how do you know it's not? It's just downloaded from the net.
No,
form.
because this is very clearly mentioned. This is original also is there, Lordship. In fact, if he is contrary regarding this, even their marriage certificate annexed by the petitioner, Lordship, that also is the deed of marriage.
The wedding sanctuary. How do we ascertain the veracity of the document?
Lordship, but I just didn't have done it. But that section 3 of the Indian Christian Marriage Act, that is actually is correct actually, because they say that any person who has received the episcopal ordination.
You want to file a jointer?
That is there, Lordship.
You will post it for hearing.
Let it go for hearing. I will explain all this.
We'll explain all. Yes. Your file after it has been filed by the concerned respondents. It's a matter for hearing after 3 weeks. Yes.
17.
That's it. Meanwhile, you can do internet check on that, on the very marriage certificate.
17, Lordship. Yes, they're supposed to file the affidavit.
Have you taken steps?
We have taken a step, Lordship. We have taken taken a step. I think my senior advocate is appearing. On the last occasion also he has appeared.
Respondent number, my lord, 6, 7, 9 and 10, my lord. And I was informed that respondent number 5 already retired.
Died?
My lord. Retired from service.
Retired.
And number 8 has already expired, my lord. He died already. Earlier I represented him in the first round of litigation.
So now how many are there?
My lord, here 4 private respondents are here.
So one's retired, one's died. So that means 5 to 10, that means there are only 3 remaining.
4 remains.
4 remaining, sorry.
4 remains.
You are
6,
paying
7,
for 4 of them. Yes.
9 and 10. But 3 weeks time may be given for us to file a...
Mr. Secretary shows inter appearance on behalf of the private respondents and submits and respondents number of
6, 7, 9 and 10.
9? No.
6,
Just now
7,
you said 9 died.
9 and 10. My lord.
6, 7?
8 died, my lord.
6, 7, 9 and 10. And five died. Five retired.
Five retired from service.
He submitted
and
5
eight-
died from service, and some 8 has since expired term. They pray for an allowed. We'll strike off the name later on.
Lordship.
Right, they pray for an allowed 3 weeks time to file the application.
Authorised, Lordship.
18.
May it please your lordships. My lord, this is the case, my lord. I need to apprise, my lord, what has happened, your lordships. This is in fact the second round litigation. Now, my lord, this is regarding settlement of Mukindur check station, your lordships. In the first round of litigation, my lord, what happened, my lord, I was technically qualified. My land was surveyed, everything. And I was qualified for the financial bid. Financial bid, I was the highest bidder, my lord. I should have been selected. I was not selected.
Yeah, I
Second,
remember, yes.
my lord, just briefly, your lordships, because there are certain things happened, my lord. I need some protection. Now, your lordship, my lord, set aside, my lord, the second bidder's appointment and then send it for reconsiderations. Now, two parts of your lordship's judgment. One part, your lordship has held that so far I am concerned, my lord. Otherwise, I confirm the requirements of the tenders. Secondly, your lordship also made an observation that if additional norms required, district council can look into it. So, matter went back to the district council. They looked into the judgment and they have decided to appoint me, lordships. But they put a condition, my lord, that I will get a better place with levies and all, my lord, infrastructure. Now, lordship will keep it in mind two things, my lord. One, by appointment by private negotiations. Now, that what the law is, law say, my lord, private negotiations, all are to be given equal opportunity. That is the one thing. But here is the case, I was appointed and then I was asked, you get a better place with levies. So, my lord, accordingly, what I did, I got a better place, informed them, invested money, build up infrastructure. So, I was expecting a formal order. Now, recently what happened, your lordships, in the month of March, they have issued a letter without any show cause, without any opportunity, my lord, stating that they have received a legal notice from the unsuccessful bidder whose appointment was set aside by this court to the effect that you cannot change the condition of the tenders. So, they have taken into consideration that legal notice and without giving me an opportunity, cancel it. So, on the last occasion when I filed this case, my lord, I filed a missed case also for some protections. And your lordship in the meantime directed, my lord, asked them to obtain instruction, and in the meantime directed your lordship, they should not float any tender, fresh tender, for settlement of this check station at Mukindur, my lord. That is all. Now, even after this order, what they did, my lord, so long they were running it departmentally from Mukindur only. Now, after my lord, lordship passed this order, my lord, overnight what they did, they shifted the place from Mukindur to 5 kilometers away to a place called Khetrisi. So now my apprehension is this, your lordship, they are out to frustrate the cause of actions. So my lord, I need some protection. Miss case is still there, your lordships. So
Yeah,
far, my lord.
Mazika, what happened?
My lord,
is that correct?
I received instruction, my lord. Can I please?
I do not know. Well, they cannot frustrate it like this. The legal notice. Can I have a copy?
I'll follow it.
Where is the Claythurshey thing?
Claythurshey, my lord, this is 5 kilometers away
No,
from.
it's not. It's not.
That's not correct.
What your records? I mean, what instructions are these?
Well, I don't know. Even he is reluctant to give me a copy.
They're all prior to the petition.
Prior to filing of the petition.
Exactly. Instructions means after what happened.
My lord, what happened even before the petition was filed, my lord?
Yes.
The district council has taken a decision now to run it departmentally, my lord. I'll file an affidavit, my lord.
No, my lord, my question is here, my lord, at no point of it.
We are not issuing, there is an interim order.
Lordship has passed on judgment.
Have you not vested some, actionable claim on the petitioner by settling the tender with her after they've done everything? So, okay, fine. I only advise that because change in location might lead to some complications which...
With the state government, my lord.
Not the state government, with whatever you comply with the whatever norms, there wouldn't be an objection. But what has happened is that the legal notice was there, and that's a change in conditions of tender. And we got to examine that.
Lordship will see one thing, you will appreciate, my lord. Lordship will
Does
not go.
that, does not mean that this will die natural death, that the department will look at it departmentally.
My lord, a tender, for right or wrong, my lord, a tender was issued. He participated in the tender, my lord. Now, the challenge before
frustrated, you mean the tender is frustrated on the terms of the original tender is inexecutable.
My lord, the employer always have the right, my lord, if they don't want to award the tender anymore.
But then before you consider that, why did you settle the contract with them and ask them to do improvement works and so on and so forth?
Well, it appears, my lord, the district council now thinks that it is best it is run departmentally.
Now it's fine, but what about that at the relevant point of time after the order of this court was there cancelling the bidder number 2 and then asking you to have to revisit it. At that time you should have said, okay, fine, forget everything, we run departmentally. Now after you look into that, you settle the contract with this the petitioner, then you say, okay, fine, as in negotiating with the parties to make the contract executable and feasible, you ask them to to relocate the site other side of the road. Now, after all that, then where will the remedy lie? Can be washed away by saying that run departmentally. So, thank you very much for all the trouble you've taken.
Lordship, the applicant, this is something like an appointment, but the applicant is no indivisible right.
Indivisible right, but after being appointed. See, you had a select list something else, but if you already been appointed, something else.
Lordship will take note of one thing, my lord. It's a very important thing. The cancellation.
Civil consequences, yes.
My lord will see the cancellation. Now he's saying all these things. What is the reason for cancellation? Only the legal notice. They are not saying, no, we have changed our idea. We have taken a decision, my lord, to run it departmentally. We will not go any further. That is not only ground, and the law categorically say when a writ petition is filed, we will confine to that.
Is that they are apprehending that by allowing you to operate from a different location will amount to it's the tender.
No, my lord. That's
the apprehension.
That is wrong, your lordship.
And so it said because that person has filed legal notice. That's all.
That's wrong, my lord. So only on that ground. Now whatever he is saying, my lord, we will run departmentally. These are all extraneous consideration. Consideration is this. So my lord, my prayer, lordship, give me some protection. But the way they are proceeding, they are out to frustrate this cause of action.
Protection is already
my lord,
there is an order.
Lordship will make it clear, my lord, that ultimately, my lord, my lord, let them file it. It's a small matter, your lordships.
Yes, Dr. N. Muzika submits instructions that please email to find affidavit to bring the instructions received on record. Stop. Prayers allowed. List the matter after 2 weeks for further orders. The interim protection granted earlier by Order 6/4/2023 shall continue to the next day.
Only thing they ensure they file an affidavit on matter. Small issue, your lordship, can be decided. Otherwise, the entire thing will be.
You have to go through civil remedy.
No. I'll satisfy your lord. This is not a case for civil remedy, my lord. This is, my lord, an appropriate case for writ where your lordship will issue the writ. I'll satisfy that.
Thank you.
Lovely.
Hearing item 19.
Yes, Mr. Adam, where's the juniors? No one's appearing. Kiripan, we makikin. Like, you know, says. Oh, thank you. Yes, Mr. Gendal.
Lordship, I'll just recapitulate my lordship's, my memory also by taking your lordship to the prayer of the petitioner, which was the last occasion.
Just 1 second. This other APR document you brought on record is not on record by your affidavit, no? It's just you've been brought it. You brought it.
Yes, original I bought it. Then I shown the original to this court and kept a Xerox copy.
Okay.
Kept a Xerox copy. Your Lordship.
Yes.
The prayers of the petitioner can be divided into two parts. The first part deals with the alleged downgrading of his APR, and the second part of his prayer deals with the denial of promotion with effect from 1/1/2016. Now, your Lordship will come to prayer number A.
Yes.
At page 37.
Prayer number A.
A. At page 37. Set aside and quash the impute downgrading of the grading of the first and the second part of the APR of the writ petitioner from very good to good for the period 1/4/2015 to 27/7/2015, as well as from outstanding to good for the period 28/7/2015 to 31/3/2016. The first prayer is this, that he wants to get the grading of good and for both the period to be set aside. Then your Lordship will see prayer number E.
No, it says set aside and quash the impudent downgradation. The downgradation
of the grading of
from
the first
very good
and the
to good.
second part of the APR of the writ petitioner from very good to good for the first period, and for the period 1/4/2015 to 27/7/2015, as well as from outstanding to good for the second period. Then your Lordship come to the prayer number E. Finally, what he wants, direct the respondent NIPCO to uphold and retain the grading that is outstanding for the period 2015 to 2016 under Rule 6.4.3 of the NAPCO promotion policy and rules.
So he said they contradictory.
Second prayer, which is interrelated with the first A, is that he wants to get a direction to retain his grading to outstanding.
E says that to retain grading outstanding, and
Yes.
A says to quash that.
Yes, to quash that and to retain it as outstanding. Your Lordship will have a look on the APR which I have produced on the last occasions.
Excuse me. Yes.
For the first period, your Lordship will see 1/4/2015 to 27/7/2015.
Yes.
It has been downgraded from very good to good. Very good to good. So question of retaining it as outstanding does not arise in this case, in the first APR. For the first period, the downgrading was from very good to good.
Yes.
And question of retaining it as outstanding
The first period, okay, just please note down.
does not
From
arise at all.
1/4/15 to 27/7/15, downgraded from very good to good.
Good. And therefore, the question of retaining it to the outstanding, it does not arise, Your Lordship. Then Your Lordship will see for the second period, the accepting and reviewing authority has graded him already outstanding, and no change is made in this second period by the director personnel, to whom he is telling that he has deliberately downgraded the grading of outstanding to good. Your Lordship will find that so far the second period is concerned,
Is outstanding.
it remains outstanding.
That was overwritten by the CVO.
Yes, Your Lordship. Though the assessing officers has assessed it to very good, but CVO has made it outstanding, and that has not been changed at all. It still remains as it is.
So outstanding.
Outstanding.
Okay.
Now the question which remains is this: whether the downgrading of the report from very good to good
Yes.
was justified or not under the rules, Your Lordship.
Right. So you're attacking this today from another point.
No, Your Lordship, I want to cut short the matter, because otherwise it will take me to a place where I'll be totally lost, Your Lordship. I won't be in a position to make out the point that basic things is only these two APR.
So now,
what effect it has?
You're improving arguments now.
Not improving, Your Lordship. With the passage of time, it becomes concise and concise.
Yes.
Now, Your Lordship will find that assessing officer for the first period,
We go back to the APR.
APR, first period APR,
Yes.
he has assessed him very good.
Yes.
Then reviewing and accepting authority has given his own finding that he had shown declining trend in his performance. An average performer who needs to be constantly monitored and supervised work endorsed directly by DP could not be done by him in time. Then in the last he gives as a accepting officer the rating very good 67 given by GM is on higher side, which contradict his remarks needs supervisions, hence rated good 57. So he has applied his mind independently and he is within his right to do so. He is not required to put his seal, whatever the assessing officer assess the person's concerned here. Now, in the remark what he gave, he assessed him very good. The assessing officer assessed him very good, but at the same time he says he needs supervision.
But then this is not communicate to him, correct?
Which one?
This
is a part
APR for communication.
Not required, Your Lordship. It is in part. It is in part. Now, Your Lordship, I take to Your Lordship what does the rule says about this. Lordship will just give me. Your Lordship will take the promotion policy, NAPCO promotion policy and rules, the copy of which was supplied by my friend.
Promotion policy. Okay. Promotion policy.
I have also, I think, annexed along with my affidavit.
One second. Yes.
At page 72, it is available with my affidavit.
No, it's here. Just come to internal page of this.
Yes, this is.
Internal
Of course,
page of
mine one is not complete. That's why he has given a full copy.
Which section?
6.4.3.
APR.
Yes.
Okay. Yes.
Now, for appraisal reports, the point will be allocated as per rating scale as under. What Your Lordship, I wanted to draw the attention at page 74 of my affidavit. Same rule.
Yes.
the power, if the reviewing authority, Your Lordship,
74 of your
page 74 of my affidavit, third para, if the reviewing authority or the accepting authority, as the case may be, has overrules any of the assessment made by the reporting officer or the reviewing authority, as the case may be, the remark of the later authority should be taken as a final remark for the purpose of assessment, provided it is apparent from the relevant entries that the higher authority has come to a different assessment conscientiously after due application of mind. If the remark of the reporting officer, reviewing authority and accepting authority are complementary to each other, and one does not have the effect of overruling the other, then the remark should be read together and the final assessment should be made by the DPC. Your Lordship, in the instant case, the reviewing authority and the accepting authority,
he downgraded to good
he accepted, he applied his mind
and downgraded the rating.
and found that the assessment made by the assessing officers contradicts
By the reporting officer.
by the reporting officers, and therefore he was within his right. Now, what allegation he is leveling, that director personnel was inimical to him, and he was so because he helped the CVO in providing the input for filing 3 criminal cases at the Lightmukra police station against the director personnel and against the CMD, as well as against the chief security officers. That is his just imaginations. From the entire writ petition, your Lordship will find the ghost of DP was always in his mind. Every place he writes.
The ghost of DP?
Director personnel.
Okay.
Some was at the back of his mind, and for everything he says that it is because
He is
of
to
the
blame.
director personnel, because I filed the cases against him, and all those 3 cases got dismissed by the competent court. High Court quashed the FIR in 1 case. In 2 cases, even the charge could not be framed, and the trial court discharged the accused at the stage of consideration of all the three. Now, it is because the atmosphere which he has created in the corporation, that has created a lot of havoc, Your Lordship.
Okay, let's not go there. Now just come back to
yes, Lord.
But you're saying that why he's not entitled to a copy of this APR, that's all, for that period. That is, we're confined to that now.
Yes.
You're showing the rule to show that he's not entitled, that non-supply of this relevant part of downgrading at the relevant point of time does not affect his case. That is trying to show, correct? Yes.
I'll show you. Your Lordship will come to page 25 of my affidavit in application. Lordship. Second para. This deals with the effect of downgrading for the first period.
Yes.
The deponent further states that the contention of the petitioner that the denial of promotion to him with effect from the date when the same was due to him was for the reason of downgrading his APR without any authority is factually incorrect and is merely a fragment of his imagination and speculations. It is further submitted that the promotion of the executive is based on many other parameters and is not confined only to APR grading, which is one of the parameters. Further, even though the rating of APR in respect of the petitioner for the period 1/4/2015 to 27/8/2015 was reviewed as good, the DPC, however, decided to review APR rating as per clause number 6.4.3 of the NAPCO promotion policy and rules by considering it as very good, because it is within the power of the DPC when there is a broken period. For the purpose of DPC, thereby giving advantage to the petitioner. But however, despite the same, the petitioner could not score the required marks in the interview parameter and hence he was not recommended for promotion. With effect from 1/1/2016. Further, though the petitioner has claimed that he had submitted some of the remarkable assignments successfully done by him in Human Resource Department during the period from so and to so and so, but his reviewing officer, director personnel, has clearly reflected in his APR for the said period that the work assigned to the petitioner directly by director personnel could not be done by him in a time-based manner, and on his independent assessment, the APR rating was reviewed. Further, the petitioner was also not recommended for promotion during the DPC held on 2/3/2017 based on his performance during the interview and not because of the APR rating or inimical attitude of the director personnel towards him. Your Lordship, it is not that the APR is the only criteria. There are other criteria. There are total 60 marks.
No, that part, Mr. Jindal, which we concerned, saying that why this part of the APR is not necessary to be communicated to the petitioner, because you say that you look at the whole year and there's a part-based ACR for a certain segment of the year. Why only that? You're on that point. Where does it show that it's not necessary?
Your Lordship, I have already pointed out for this period, broken period, DPC will take a call.
No, communication.
That's what I'm telling you, Your Lordship, because unless for one part,
DPC will take a call and say DPC, okay. Lordship will take as very good, well and good.
Lordship
fine.
Lordship will just bear with me. If the DPC accept it as it is,
then here a cause of action.
Then there is a cause of action. But here in this case, DPC has taken it as a very good, though the director personnel has.
No, DPC then they just balanced it because one part is good, the other part is outstanding.
Whatever
So in the middle is very good.
Yes,
so that's
yes,
very good.
yes, very good.
Yes.
They have rightly done. So even for the less than 3 months period, it was not required to be written, but it was written because he submitted. He submitted. Now your lordship will just have a look on page 16 of my affidavit.
1/6.
1/6. Further, it would also be pertinent to mention here that for promotion from E5 to E6.
Sorry, once again. Yes.
Further, it would also be pertinent to mention here that for promotion from E5 to E6, the incumbent has to obtain more than 50% marks in each of the criteria. It's not, your lordship, that A, B, C and they take a average. This is not the case in the case of promotion from E5 to E6. He has to score 50 marks in each column. I read once again, your lordship. Further, it would also be pertinent to mention here that for promotion from E5 to E6, the incumbent has to obtain more than 50% marks in each of the criteria, that is length of service, APR rating and personal interview in the instant case. In the instant case, the petitioner was unable to score more than 50% marks in the interview, although he scored 50% marks in the rest of the criteria. In the APR, he has already scored 50% marks. But in the interview, he could not make out to the 50% requirement, and therefore he was not selected or he was not recommended for promotion. So for the second DPC is concerned, your lordship. In the third DPC, he has been promoted. He has been promoted. Now he says that though the promotion has been given to him from 1/7/2016, but financial benefit are conferred upon him from the date of joining, your lordship, because equal pay for equal work. If there no work, no pay, no pay. If he has not worked, this is the fundamental rule, your lordship. This is the mandate of the Apex Court, that if a person has not worked on a particular post, he is not entitled for the salary for that period, your lordship. And moreover, so far increments are concerned, your lordship, he was given increment from 1/1/2016. That period was notionally taken for the purpose of fixing his salary as well as for giving the increments. And he got all increments, what he was due from 1/7/2016. Only for the period from 1/7/2016 to the date of joining, he was not given the financial benefit of the promotional post because he has not worked on that post, your lordship. Now, so far third DPC is concerned, your lordship. Third DPC, he was recommended. He was recommended for promotion. So, he has no grievances so far his promotion by the third DPC is concerned. Now, what grievances he is having, that this third DPC was a review DPC. And once it is a review DPC, it should relate back to the period from which the previous DPC was held.
Okay.
To that effect, Your Lordship, our submission is this, that it was not a review
DPC, it was a fresh DPC.
It was a fresh DPC. And for that, Your Lordship, I'll point out Rule 23 of the promotion policy. Lordship, the review of DPCs. Lordship, got it?
Page?
In my, Your Lordship, unfortunately, this page is not there. Separate, he has given. He has given.
Page number 19, man.
Page? Internal page 19.
Review of DPCs, point number 23.
My lord. Review of DPC, page 19.
Your Lordship will see, when review DPC may be held, the proceedings of any DPC may be reviewed only if the DPC has not taken all material facts into consideration, or if material facts have not been brought to the notice of the DPC, or there have been grave errors in the procedure followed by the DPC. Thus, it may be necessary to convene review DPC to rectify uninterrupted mistake, for example, so and so. It doesn't fall under this category.
Yes.
It doesn't fall. So it was a fresh DPC. Now, his claim is also this, that he should be given promotion from 1/1/2016, and his seniority should be maintained over those junior who has already been promoted by second DPC. Your Lordship, my submission is this, without going into the merit of this, his contentions, those persons who are going to be affected are not before you.
No, you mentioned it earlier. Yes. Yes.
Now, so Your Lordship, in brief, Your Lordship, my submission is this, that no irregularity has been committed, Your Lordship, in promoting him. Second DPC, in the first DPC, Your Lordship, position was this.
Yes.
He has made a representation to the CMD that director personnel was sitting as a chairman of the DPC, with whom he has some issues, and therefore the procedure was not properly followed, and moreover, DPC was also not constituted as per the mandate of the rules. CMD agreed to his representation, not only his promotion order, but all the promotion order by the first DPC were set aside. Second DPC was held. Second DPC has taken both the periods ACR into considerations and made their own assessment and assessed it to be a very good. But he could not make 50% marks in the interview, and therefore he was not recommended. Recommended. So far the third DPC is concerned, he was recommended, and for higher promotions, and the promotion was given from 1/7/2016, and it was not a review meeting. It was not a review DPC, but was a fresh DPC.
It was given 1/7/2016.
Pardon, sir? 1/7/2016.
Okay.
From 1/7/2016 we have given it. Now, Your Lordship, only one judgment I will cite it, that is 2003 7 SCC 238.
Seven SEC. Seven.
2003 7 SCC, page number 238, 3-judge bench.
Yes.
Paragraph 8 and 9. Paragraph 8 and 9.
Yes.
In State of Haryana versus O.P. Gupta, this court had occasion to deal with a claim for arrears in a case wherein adjudicating a dispute relating to seniority. This court directed the department concerned to prepare a fresh seniority list strictly in accordance with the rules, ignoring inconsistent administrative instruction, and in compliance thereof a fresh seniority list came to be prepared, and eligible persons were even given notional promotion by the department from a deemed date. When such promotees claimed for payment of arrears of salary as well, this court rejected the claim, applying the principle of no work, no pay, and set aside the order of the High Court. Countenancing such claims to be illegal for the reason that the promotees did not work for the period in the promoted capacity. In coming to such conclusion, this court followed the earlier decision reported in so and so. Paragraph 9. So far as this case on hand is concerned, the appellant was denied promotion in terms of the promotion policy, under which it was necessary for a candidate to secure at least minimum eligible marks of 6.5 at the interview, and the learned single judge allowed the claim only on the ground that such prescription of minimum marks was not valid. Though the division bench also affirmed the same, this court overruled the said decision and upheld such prescriptions. But taking into account the pendency of the appeal in this court for a considerable time, and on account of which the appellant also did not appear in the subsequent test, benefit to promoter was not denied. The fact that her non-promotion was legal, and there has been no unlawful interference with the right to promotion or to serve in the promoted category was obviously and could not be minced over or completely ignored in the light of the judgment of this court, allowing the appeal by the bank. While that be the position, the grant of relief to her, keeping in view the delay merely due to pendency of proceeding before court, was more in the nature of a gesture or grains and not by way of any right to which she was found to be entitled to. Consequently, the notional promotion given to her by the bank with suitable revision of her pay scale itself is more than sufficient to meet the requirement, be it either in law or in equity. The further claim for payment of arrears as well as for fetched and can have no basis in law. The division bench in our view properly approached the question in the light of the relevant guiding principle, and the same could not be said to be either arbitrary, unreasonable, unsound in law to warrant over interference. Here it applies to the same here, Lordship. Now, my learned friend has cited two judgments, Lordship.
You can conclude in half an hour and you can conclude, Mr. Jindal.
Sir, I'm concluding, sir. I will take 10 minutes more.
You can conclude replies in 10 minutes.
Your Honor, then I'll just point out only one thing here. First judgment he cited.
Now, what judgment cited, Mr. Chaneso?
He cited one AIR 1978,
Yes.
Supreme Court 851. 1978 AIR 1978 Supreme Court 851.
Name of the parties?
Name of the party Mohinder Singh Gill and another.
I mean the famous judgment, yes. Mohinder Singh Gill.
No, Your Lordship, this case relates to tender contract.
On what point you cited Mr. Chaneso last time? Mohinder Singh Gill, on what law point?
Relating to the fact that the grant of benefits was denied to me because of the decision taken by the board of directors. Now, that is the reflect in the annexure. Now, in the affidavit they have said that no, it was taken denied because reading with the fundamental rules and Supreme Court decisions. So they are supplementing the reasons.
So, Your Honor, so far the first case is concerned, Your Lordship, Mohinder Singh Gill case. This was a matter relating to the tender, and they have relied on para 4. I just refer to para 3. The moral may be stated with telling senses in the words of William Pitt. They are writing some quotation. Natural justice is no mastic treatment of judge-made justice, but the pragmatic yet principles requirement of fair play in action as the norm of a civilized civilized justice system and minimum of good government crystallize clearly in our jurisprudence by a catena of cases here and elsewhere. The conspectus of facts, Your Lordship. So, Lordship will also see para 8. para 8, the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the regions so mentioned and cannot be supplemented by fresh region in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of challenges, get validated by additional ground later brought out. We may here draw attention to the observation of so-and-so. What I wanted to point out, he has cited this judgment that when a statutory functionary, it applies to a functionary which is created by a statute.
Yes.
In our case, the action of the functionary which my learned friend is complaining is not that of a statutory authority, and therefore this judgment has no relevance. Similarly, Your Lordship, in the case of second case which he has referred, 2016 1 SCC 724, to which case? Paragraph, no? This also, Your Lordship, will find deals with the statutory functionary. That action of the statutory functionary, I just read it. There can be no gainsaying that paragraph 4 I am reading. There can be no gainsaying that every decision of an administrative or executive nature must be a composite and self-sustaining one, in that it should contain all the regions which prevailed on the official taking the decision to arrive at his conclusions. It is beyond cavil that any authority cannot be permitted to travel beyond the stand adopted and expressed by it in the imputed action. If precedents are required for this proposition, it can be found in the celebrated decision of so-and-so, of which the following paragraph deserve extractions. The second equally relevant matter is that when a statutory functionary, the earlier case which I have, Your Lordship, pointed out, they have relied this case. And since the first case does not apply, this second case also does not apply in the instant matter. In the second writ petition, Your Lordship, he is assailing and he has made A.G. West, who was at the relevant time CMD, and who has passed one order in the note sheet stating that this should be, that financial benefit should be given from the date of joining. Now, he alleged that this is malafidely done in order to deprive him for the financial benefit, and in the second writ petition he has made the then CMD A.G. West a party respondent, to which I have filed an application which is pending before this honorable court.
For striking off.
That striking off his name, Your Lordship. Now, Your Lordship, all powers are vested with the CMD, Your Lordship. Now, the matter was, it's not that everything is taken, is recorded. There are certain matters which are informally discussed in the board meeting, and power lies with the CMD.
Yes.
In some of the matters. Some of the matters are beyond this. No, he took a decision that financial benefit should be from the date of joining. No, he though has not mentioned that under what provision or what law. No, the law is well settled. Maybe he has not reflected in his note sheet that, but it cannot be disputed that the law is not settled. Law is well settled, and I have pointed out the 3-judge bench judgment of the Apex Court that no work, no pay. This is the fundamental principles. You may give the promotion notionally from the back date when it was due, but it cannot be directed that for this period he should be paid the salary of the promoted post. No, there is nothing wrong in that, Your Lordship, to my understanding. My friend is trying to put it in a different manner and putting the management in a very embarrassing position, making the CMD a party, and where he ought to have made a director personal a party, he has not made. In the first writ petition, the entire writ.
But you're appearing for him, General.
Sir, I am appearing.
No, for the second petition, you're saying?
I am appearing. Both these are interconnected, Your Lordship. So my submission is this, Your Lordship, that there is nothing wrong in that. Even if that order goes, the law remains. No pay, no work, no pay. That cannot be altered. Even if Your Lordship find that no, this note sheet is illegal, ought not to have been, then what comes next? The law is settled. And my submission is there is nothing wrong in taking such decision when it is within his power. At one line you have stated, my friend's case is this, in one line you have stated that, in second line you have stated, therefore it is a mala fide intention. Maybe sometimes, Your Lordship, is the mistake of draftsman or the person who prepared the comments. It might be so, Your Lordship. But with regard to the right of getting the salary for the back period for which he has not worked, it is well settled. So that is what is my submission, Your Lordship.
You close submission?
Pardon, sir?
You close submissions?
I close my submission. I am before time today.
Yes, Mr. So.
Within this 15 minutes, I'll give my reply, my short reply.
Within?
This 15 minutes, my permits me.
Or you take tomorrow?
In this 15 also, I can finish.
Why it's just saying tomorrow? Because in case you say something which he, it merits a reply from him. That is why it's up to you. You've dragged this matter long enough. I've also.
Actually, sir,
tomorrow also it's okay.
There are two advocates have come from Delhi. They are waiting in the commercial court. I'm a bit pressed.
So you're showing them professional courtesy.
What to do, sir? They have
As
come
a first
from
item tomorrow, but Lordship has given us enough time to both of us. I'm grateful for that.
We can close it also.
If he's sure, but he's also like me
CA has
only.
taken longer
He's
time.
also like me only.
We will continue tomorrow.
But
I conclude.
Yes.
Highly obliged.
hearing to continue tomorrow.
I can.
Yes, Mr. Fikir has concluded arguments. Replies by Mr. H. Zamriso. See and figure tomorrow.
Both the cases. Yes, there are 2 reports.
27. 27.
Which one again? Which one again? Munshak Ali. Where's the election petition?
Second call, please. Second call, please. Second call, supplementary list. Item number 1.
Is a second petition same for Mahendraganj? It's early on to Mahendra.
Error in the synopsis of the other election petition was because the synopsis of this petition went there. That's why you might have referred to my.
Or is it to read?
That was 43 ST constituency. 43 ST constituency.
No, this one was moved yesterday and the synopsis is wrong. This is the one.
No, sir. This is different.
Now your senior saying that you're still saying this is the wrong synopsis again?
I know the synopsis for the other matter where we do not.
Oh, this had gone there.
This is gone.
Oh, that also that's why. Okay, deja vu. Yes. Okay, yes. Right, yes. Page? Yes.
The respondent, in his affidavit filed before the courts, before the returning officer, says at 9B that as many as 8 government contracts are pending with him, Your Lordship will kindly see 9
I can see it. Contracts with the corporate government. Detailed contract, final work order, final. Yes, all final work orders, yes.
My lords, these are work orders under which work is going on even today.
How do you say that?
We have made categorical affirmance, my lords, and we've also annexed photographs.
So you can see that now. Just come to the first one, 2020. The other one is 19. Number 3 is no date. It's 21.
Is, my lords, 21.
21. No.
Number 4 is 21.
20. Then again you come. Now how do you say that it's subsisting?
My lords, he says it in the affidavit.
Where is that?
Well, because he says, these the contracts with appropriate government or public company or companies, which if they were been concluded, there was no requirement of the respondent to make these statements in the affidavit filed before the returning officer. Interestingly, if I may just take your lordships to one more page, if your lordships kindly have a look at page 37.
Yes.
Now, in connection with one of these contracts, there's a matter pending before the Lokayukta. And your lordship will kindly see a D. A building contract was allotted to the candidate by the Garo Hills Autonomous District Council, Tura. The building is half completed. The candidate had completed the work as per the amount released, but the complainant filed a petition before the Honorable Lokayukta and the candidate did not complete the work.
Yes.
So the fact of the matter remains, my lords, he really does not deny that there are subsisting contracts.
Okay. Yes.
So, my lords, my humble submission would be then section
So only on
9A of
so now your grounds only on subscription contracts hit by 9A. 9A.
9A.
Okay, yes. We'll issue notice. Take steps. I next matter.
2.
It seems the ones who are preparing affidavits, these lawyers, you see, it's a very crucial thing. They were preparing affidavits for candidates. They have to be very well aware about the. They're well aware
done
about.
very casually, my lord.
Yes. Yes, well aware
It
about
was
the
done very
requirement of law.
casually till now.
Yes.
I think now, my lords, the scenario would change up with these challenges happening in court.
Yes. Because they have to be very.
Well, look, item number 2 is a little different, my lords. There is a very interesting matter. Lordship, what had happened is, if I may take your lordship straight to page 23, page 22, my lords.
Yes.
Now, this is a letter that is issued by the Chief Electoral Officer, my lords, of Meghalaya to all district election officers. Your lordship will kindly see, I'll just read it very quickly, my lords. With reference to the subject cited above, I am enclosing herewith letter number so-and-so dated so-and-so as received from the Election Commission of India. In this connection, you are directed to issue necessary directions to the concerned presiding officers of your respective districts, where cases of non-deletion of mock poll was detected.
What is this? What is non-deletion of mock poll?
Well, what happens is, for the purposes of testing these EVMs, there is a mock poll which is conducted, my lords, on a prior date, then the date of poll as notified in the elections. Now, the procedure, my lords, which is required to be done is that all data in the EVM has to be deleted prior to, my lords, the election date, so that it is a fresh machine on the election date.
Okay.
Now, in respect of, my lords, at the table down below, at serial, your lordships kindly see 33 Rambrai
Yes.
Jirang constituency.
Yes.
My lords, 52 is the polling station number. Rambrai.
Right.
Now, the mock poll results of that particular EVM were not deleted.
So what impact does it have on the actual polling?
Because what would happen, my lords, it's like this. If there were 500 votes cast on the election day, the EVM would essentially have 500 plus whatever was the figure of votes, my lords, of the mock poll. Because that information is not deleted.
No,
And
but mock
because
poll,
of that,
you mean mock poll, I mean it was the EVM was, the key was pressed with regard to particular political parties. Is that the
yes,
case?
my lords, that is done. It is randomly done, my lords. It's like a mock election that happens with the mock poll. So that is why, my lords,
And
it
so
is
your submission is that if that mock poll, whatever that exercise was done, if it's not deleted from the machine, the total of those votes cast for mock poll will go into the tabulation of the other votes.
It will go into the main result, my lords. That's what I'm submitting before your lordships.
We need some
And,
clarification
my lords,
on this.
coupled with the fact that I was defeated by, my lords, only 110 votes. As a matter of fact, my lords, we put it on record that this EVM had also malfunctioned. The original decision of the returning officer was not to count the votes here, but considering, my lords, the difference of votes being minimal between me and the return candidate, as the last minute measure, this particular EVM was taken in for the purposes of, my lords,
No, but isn't it mandatory? Like suppose when the results are very close, that the results are counted twice, is re-tabulated.
It is done, my lords. But the difficulty here is, my lords, initially this EVM was not opening. And after it was not opening, my lords, finally they counted the VVPAT chits. And on that, my lords, through 110 votes, my lords, I was declared defeated. Now,
That's what now. When a mock trial is done, will the VVPAT the slip come out? Is it generated
my lords,
also?
Yes, my lords, because it is the entire procedure goes through, my lords.
Interesting, but I don't know how far will have impact.
We'll have to establish it in the course of the proceedings, my lords, before your lordships.
Okay, we'll issue notices. Take steps.
Highly pledged.
The first time I've heard of this, that a mock poll is there and the votes are,
Well, it's provided in the election handbook of the returning officers that the mock
we need
poll
the
is to be
handbook also.
Yes,
Mr.
Lord.
Chancellor, you are
And after the election,
next
the
day, you
populace
just
will
bring,
be
give us a handbook for the 23 elections also.
We'll produce it in the course of the proceedings.
You kindly supply to the court, yes.
Item 6.
Right.
Item 6.
Yes, Mr. Paul Jenny Kharmolong.
My lords, item number 3, that affidavit we filed it, my lords, a copy has been served on my learned friend.
6.
6.
Item number 6.
My apologies. Item 6, my lords. Now, what we brought on record, my lords, if your lordship kindly have page 5.
Yes.
Third paragraph from page 5, my lords. This is the minutes of the meeting between MPC and the tenants, my lords, held on 6/12/2022, my lords. And your lordship may kindly have the third paragraph. The tenants were told that the dilapidated condition of MPC building and how it has become a very serious safety risk to its occupants and therefore require an early and positive response by the tenants to consider the offer of the management to accommodate the tenants on completion of the building and to vacate the rooms at the earliest. The managing director had informed that makeshift stalls are being arranged by the contractor within the construction site so as to enable the small shops to continue with the business without being totally displaced. Now, this is what had happened, my lords, on 6/12/2022. Now, all of a sudden on 6th April 2023, where your lordships would find it at Annexure 3, my lords, page 7.
Yes. Yes.
My lords, they refer to another meeting dated 9th of December 2022.
Where's that meeting? Yes.
There is no meeting, my lords, on the 9th of December 2022. There is a meeting on the 6th of December 2022, which I pointed out before your lordships, my lords. And at page 6 are the signatures of all the people who, my lord, had appeared for that meeting.
Yes.
Now, my lords, they refer to 9/12/2022 and they say that you shall be accommodated in the new building of Police Bazaar once it is commissioned.
Yes.
In view of the above, you are requested to kindly extend your cooperation on the matter by vacating the building within a period of 15 days. Now, my lords, the other arrangement of continuing with some alternative space during the period, my lords, of the construction, this has completely been left out by the respondents.
Mrs.
Lordship, just kindly come back to page 5. My friend is glossed over one particular paragraph.
Yes.
The last paragraph, my lords. A few members stated that they have always supported the project as it would not only ease congestion but also beautify the Police Bazaar area. The tenants wanted only an alternative accommodation during the construction period. This is one part. The second part is also a written assurance from the department that they would be given accommodation once the building was completed. So this written assurance is what is available on the 6th of April. Now, what my friend says, there was no meeting on the 9th of December. There is no averment in his affidavit that there was no meeting. They've had series of meetings. Now, as far as the question of giving them alternative accommodation during this interim period, that was for the contractor to arrange. Perhaps the contractor has not been available to do that because of paucity of space. But that does not mean that the original assurance is not available. The assurance is very much available on.
Where's the 9th December meeting?
I am not disputing.
Do you have a copy of that 6th?
I don't have it at the moment, my lords. This was served to me this morning at 10:36.
Anyway, we just record, after it's been filed by the petitioner, bring on record the subsequent developments in the matter with regard to the, subsequent to the matter, it is noted that reference is made therein to a meeting held on 9 December 2022, wherein an undertaking has been given by the corporation that the petitioners will be accommodated in the new building. You produced that meeting, yes, sir. Mr.
6th of December.
Mr. S.M. is allowed to produce for relevant records on next date. After 1 week, this matter after 1 week. Yes. What other matters are there? Any hearing matters which are urgent?
Item number 20.
Item number 20.
Yeah, that you have to assist the court. It's a very interesting matter.
Yes. The court so desired and will take it up, will argue. Otherwise, I mean, if there's still
It's up to you if it come back at 2 o'clock.
If the court wanted to have recess, no?
No, yes. We come back at 2 o'clock. We'll have it. No problem. Mr. Kanta, he looks reluctant. No, 2 o'clock. You ready? 2 o'clock. You want to?
I've got some other matters.
No. We'll have other matters. The only other court in the state which takes precedence over the court, Chief Justice Court.
I'm
But have you
not to disclose your lordship because it is in the
confidential matter or the private matter?
Huh?
You have to attend the private matters.
No. It's I've got a hearing in the subordinate courts where my attendance is required, relating a similar issue of counterclaim.
Very interesting matter. We have two judgments and the other,
two judgments
the other Supreme Court judgment just glosses over, with due respect, refers and glosses over. It refers to and glosses over that aspect. A very important, very interesting point. I mean, for the general members of the bar also is very interesting this point. Whether a suit is filed, the prayers made for specific, specific prayers there, maybe for declaration of, suppose for certain plot A. Counterclaim is filed with regard to another portion of land, including that plot A, another plot B is brought in.
But that has been clarified by
Now,
the authority.
after plot A has been settled, whether the counterclaim survived plot B when the plaintiff never sued for plot B. Now, Mr. Kanta says that no, now it'll be maintainable. Well, once the counterclaim is put, it must be answered. Right, multiplicity of proceedings. But Mr. Marpan says no. If that matter sues only for plot A, so if the counterclaim is plot A and B, notwithstanding they want for plot B, they can very well file a fresh suit. So where does it stand? And Supreme Court judgments, there are two.
But the one I've relied on is the larger bench, the three judge.
Whatever this, but that's glossed over. Mr. Marpan has glossed over. He has just made a passing reference, but has not given any clear finding as to whether counterclaim survives or not.
The question here, Your Lordship, is
what do you have to say?
Whether
let us take the bar, because actually what happened was that this matter we had heard them at reserve for judgment. Then when I was studying the relevant law, we saw this, that it's not really, there's no definitive kind of a thing.
What is the primary question here, Your Lordship, is that whether in a suit for injunction, counterclaim for injunction in respect of the same or a different property is maintainable or not. That is the issue.
It's the same thing. Permanent injunction, declaration, whatever, is the same thing. It comes the same thing. Only thing is that whether he had sued for plot A, you settle with him for plot A, but you raise the counterclaim for plot B. Yes. That's the only thing. And why it's interesting? Because it rises from the same gift deed. That is why the difficulty is there. If it's totally independent, Mr. Kinta, the school have no problem in separating the cause of actions. That's the only thing.
Lordship, in fact, I'm here to assist the court.
That is why I need assistance.
And
that's why on last time when we had relisted this matter, that is specific, that please assist the court, we have to come to.
Your Lordship will have to look at another angle also.
Whatever angles are there, we'll look at all the angles.
After the defendant has filed a counterclaim and the plaintiff has not sought for exclusion as provided under Order 860, but has filed a written statement to my counterclaim. That is also a thing. Now,
we look at other aspect also to avoid multiplicity of proceedings.
Multiplicity.
Whether anyway.
Ashok, I just want to clarify the authority that they have relied on. This has been overridden by this one. In this one,
not really, Mr. Marpan. You see, it has glossed over. I look at the judgment.
Yes,
it just refers to the judgment where it says that the counterclaim will survive. Exactly. Now, in the judgment, that other judgment says that once that one part is settled, counterclaim for it has to go to a different suit.
The question which was in the authority they have cited has been answered in the authority that I have cited.
I wish it was that simple, but the court not convinced. Yes.
Judgment of the Supreme Court says that I cannot file a suit or a counterclaim insofar a property where the plaintiff is not having any claim. I cannot file a counterclaim.
Exactly.
It must be a property where the plaintiff is also having a...
That's the beauty of civil law, really. Yes, Mr. Mojga, something to say?
What's the matters?
Yes. So what to Ms. Kinta?
Not after a week.
Okay, after 1 week. But please try to come with some authorities. I've not had the time to look at myself.
Yes, thank you. Let's
Item number 40 is with Ms. Karpana.
It's
At 2
for
o'clock.
instruction by the respondents regarding the nursing allowance.
Oh, you have limited your prayer.
Yes, Your Lordship.
Well, I have to file an affidavit, my lord.
Why?
To answer.
You're going to deny it?
The answer which they've sent, my lord, is that it was discontinued from 2019 and he was regularized in that post after that, my lord. So it is not been.
Jugendra Singh.
Yes, Your Lordship. But with effect from 2002, Your
Okay, Dr. Mozika submits instructions have been received and praise will be allowed to praise the same by your affidavit. Accordingly, let's this matter up to 2 weeks, yes.
My lord,
Lordship, can I repeat again? This item number 20, in the instruction, we want 2 weeks.
Which instruction, 20?
I mean, I wanted 2 weeks.
To prepare the matter?
No, they telling me they will not be in town. 2 weeks, Your Lordship. Item 20.
2 weeks, yes. Okay. Yes.
my lord, 36. Next to
Sohail Ahmed.
No, Gobind Singh Bhatia.
Gobind Singh Bhatia, 36.
20?
36.
36. Is what 36? Otherwise, his court's there at 2 o'clock if hearing is going to take up. There's no. We're just giving you since Shillong lawyer is not used to post lunch sessions. 2 weeks.
My lord, 37 is the, my lord, Mr. Paul is on the other side. This is a bonded warehouse matter, my lord.
Ready with the matter?
After 4 weeks, my lord.
The division bench is already seized of the matter.
It's getting like Indo-China talks, peace talks going on forever.
After 4 weeks, my lord.
4 weeks. As talks of settlement are still undergoing. Yes.
35 is a Komoro limestone, my lord. Mr. Paul is there.
Mr. Paul is.
Yes, sir. Your Lordship,
ready?
We have received a copy of the affidavit filed by the state. So
that was
we'd
filed long time ago.
No, Your Lordship.
No, madam, I've already filed quite
One,
some time
we
back.
received the
This
thing
matter
on
has come the third time after filing the affidavit.
Yes.
1/3/2023, Your Lordship. After that, the matter was fixed on 23/23, and today, Your Lordship. So we'd like to file our rejoinder.
You'll file a rejoinder to that?
Yes.
You never prayed for it before?
It's already listed for hearing for quite some time now.
It's on, okay, 1 week.
Lordship, 2 weeks because the
Okay, 2 weeks, you file
MD
it.
is out of station.
Yes, Mr. D. Thaba, the constable petitioner, submits that though the affidavit has been filed the 1st of March, he has instructions to file the joinder. He has received instructions very recently. He prays funds out 2 weeks to file the joinder, the affidavit filed by the state respondent. Yes.
34, my lord. Mr. Paul is there.
34 and
We'll take it at 2 o'clock.
in fact, we were expecting that to come in this first half.
No, there's no expect. We can.
Otherwise, this is not an urgent matter, my lord. It is only compensation for wrongful detention, my lord. That is what they are asking.
We'll have it next week, over subject to your lordship's convenience.
Okay, 1 week, yes.
After 2 weeks, Your Lordship. Because next week I'm likely to be out of station, Your Lordship. After 2 weeks.
Mr. Parasaji, you want 3 weeks? Oh, you know the matter. Okay, 2 weeks, yes.
What's your item number 42?
Any urgency? Why?
CRP, Lordship. CRP.
It is?
CRP, civil division.
This court likes civil division petitions. Why 2 weeks? 22 matter, okay. 2 weeks, yes. If there are 18 or 19 matters, yes.
May I please, Your Lordship, I beg to mention item number 27, 28, Your Lordship. Let this matter be taken after 2 weeks, Your Lordship.
This is 27th. We won't allow 1 week only. We'll list it after 1 week. We'll finish it off. This is 17, 18 matters. 1 week. You tell me the day to be here.
28 is connected.
28, yes. 2020, yes.
On
I'd like to make a mention of item 39.
39, 39.
Let's Mr. You ready with the matter?
Yes, sir, but it's not urgent. Let him be.
See, he's very good. See, he's got a good attitude. He's ready with the matter. 2 weeks, okay. 21 matter. I don't. Hmm? Remember, all of you are on live streaming, and we know that a lot of your clients are watching now. Yes.